Okay. This is the Sunshine Ordinance Task Force. We have quorum at 4:15. Please call the roll.
Member LaHood?
Present.
Member LaHood present. Vice Chair Josh Wolf, not present. Member Tesfaye, not present. Member Martin, sorry.
Present.
Member Martin present. Member Highland?
Thank you.
Member Highland present. Member Yankee?
Present.
Member Yankee present. Member Hinsey?
Present.
Member Hinsey present. Chair Wolf?
Present. And Vice
Present.
Chair Josh Wolf is present.
Okay.
Just walked in.
Vice Chair Wolf?
Present.
We have a quorum.
Okay, thank you. Any changes, adjustments to the agenda?
You need a re-meeting to quorum.
Sorry?
Quorum?
Oh, meeting to quorum, yeah. Any member of the Sunshine Task Force may call for decorum due to disorderly conduct of meeting participants. Persons who engage in threatening and/or menacing behavior may be asked to leave. Okay, any changes or adjustments to the agenda?
None?
Okay.
Okay.
Let's move on to our first item.
Item number 2, approval of minutes from the Sunshine Ordinance Task Force December 4, 2019 meeting. Any
Any
changes?
changes, adjustments?
One tiny one.
Okay,
The
thank
vote count is missing, page 5, the one right before public comment. The actual number. Rise.
Oh, yes. The vote count for the...
The motion
For the motion
on page,
doesn't have, on page 5, just above item 5, public comment, where it says the motion passed by the following vote, ayes. It lists the names, but it does not list the vote count, the number. Look for item 5 on the minutes. And look above it for the vote,
Oh,
vote
I see.
count. See, okay, great.
okay.
Any other changes or adjustments to the minutes? Seeing none, is there a motion to approve the minutes?
So moved.
I'll second.
Moved by Member Highland, second by Member Yankee. Any public comment on the minutes? Seeing no public comment on the minutes, can we take it by acclamation? Seeing no objection, motion is approved. Let's call the next item, please.
Item number 3, file number 19011, complaint filed by the Library Users Association against Teresa Buckley, Jose Cisneros, Krista Brown, Anna Studherer, in the Office of the Treasurer and Tax Collector for allegedly violating Administrative Code Section 6721A, B, C, by failing to respond to a request for public records in a timely and/or complete manner, and by failing to provide the requester with assistance by directing the requester to the proper office or staff person.
Hey, Member Martin, do you have any report from the complaint committee?
Yeah, vaguely. I think we heard this almost a year ago. And it has to do with, I think, Mr. Minardo not being really someone that they have in the context, or claim they don't know in the context of their system. And we found that the records were, where we sent it here, obviously. So that's what's going on.
Okay, great. Okay, let's hear from the parties. Mr. Warfield, or Library Users Association, you have 5 minutes.
I'd like to ask if this needs to go forward at this time. I think it's an overwhelming mountain to climb when I need a unanimous 6-0 vote from only 6 members being present, and I understand.
There's 7 here.
Okay. This is a fairly straightforward case. I'm not sure I understood what Mr. Martin said about the determination of the committee, about what they found with respect to the information about the person in question. Basically, the simple thing is this: as our complaint subject says, and the first paragraph, we asked for something, and the Treasurer and Tax Department said no. So what did we ask for? We asked for the contact information of the author of a 41-page report who had contracted with the city to do this work on behalf of the Treasurer and Tax Collector, to provide the library with advice about and information about the impact of fines and what they should do about fines. Ultimately, this resulted in a major policy change. We simply asked for the contact information. If this had been a public employee, the public information, obviously they would have a public email and a public phone probably, and so on, and there'd be no question about that being clearly disclosable. So the response that we got, the complaint is on your page 14, and it says, it's a complaint and a request for public hearing regarding the San Francisco Treasurer and Tax Collector, Jose Cisneros, and 2 senior staff members for refusing to provide any contact information for an author who worked with, and we understand how to contract with, the Treasurer and Tax Collector. The author, a scholar at the University of California, had a contract to work with the Treasurer and Tax Department to prepare a research paper regarding San Francisco Public Library fines and fees. So the Treasurer and Tax Collector's response is way back on your page 42. And the key to it is any responsive, I'm reading from their letter, any responsive records we may have are exempt from disclosure under state and local law, as disclosure would reveal personal identifying information and may invade the individual's right to privacy under Government Code Section 6254C, Article 1, Section 1 of the California Constitution and Evidence Code, Section 1040. Accordingly, we are withholding responsive records. So we filed the complaint shortly after, and their response seems to be in multiple portions. I'd be interested to know whether their February response in 2019, in what way that differs from the January 2020 response that they have filed, and I'm not sure it's even in the file here. They pretty much threw everything but the kitchen sink at our request, and I think there are many problems with what they have claimed as support for their position that this is non-disclosable personal information. This is information that the contractor who was doing business with the city was operating through. We weren't asking for home things. We were asking for how he was communicating to get the contract, how he was communicating with the Treasurer and Tax Department, how he was communicating with all of the library people that he interacted with. So this information was well spread around in a number of departments, and I don't believe it was anything personal because it was a business. If he wanted to do a separate business thing, there's been no showing that that this was not a business thing through which he operated his business with the city. So we'd like you to find that the Treasurer and Tax Department is in violation of, I may have the section wrong, it may have been section 67.24, public information that must be disclosed. And I'd be very glad to answer specific questions about specific citations of the law that they have in multiple places provided to you, none of which I think justify the withholding of this information. Is my time up?
Yeah.
Thank you.
Are there any persons or witnesses providing any facts or evidence on behalf of the petitioner or the complainant? Seeing none, is the respondent present? Please step forward. State your name. Yeah, oh, I'm sorry.
Speak into the
I
microphone.
think she did. Just before we move on, before you start, please recognize member testify. Was it 420? 416? Okay, you got it. Great, thank you.
Okay, Teresa Buckley for the Office of the Treasurer and Tax Collector. So good afternoon, members of the task force. Thank you for having me back. It's been almost a year. We are responding to Mr. Warfield's complaint about our response to his request last January. As outlined in our written response, it is true that we did not disclose the information requested. We don't believe there's any evidence that we failed to respond in a timely or complete manner. We understand that Mr. Warfield was particularly interested in seeking an email address and phone number for the person who assisted with the library task force report. The report was written by the Treasurer and Tax Collector's staff in conjunction with this student at UC Berkeley. It was actually a graduate student at the time. He may be graduated by now. I believe he probably is finished. The reason why we were not able to disclose this information is that it's not really accurate to say that he was a contractor in the common parlance with the city. He took this project on as a one-off project as part of his graduate studies. His email address was his private email address. It wasn't a business email address or one that he used as someone who was a sole proprietor or the like, conducting business normally. And the phone number address that we had for him was also his private mobile phone address. It wasn't a business address or something that was part of a public office that he had set up. And for those reasons, we believe that information is exempt from disclosure under both the California law, 6254, as well as the California Constitution, and that providing this information would invade his privacy, and that's why we did what we did. I know that Mr. Warfield's original allegation also referenced our failure to assist him in finding the information he needed or not pointing him to the appropriate other departments. We don't believe that allegation has any basis. In fact, we spent considerable staff time, I'm talking hours of staff time, to assist him with his inquiries about the library report. We answered whatever question we could. We were very patient. We invited him to attend the library meeting that talked about the report. I feel like the record is pretty clear on what we did to assist him in helping understand what happened, and we went above and beyond that, and we don't believe there was any violation here. That's it.
Okay.
Okay.
Are there any persons or witnesses providing any facts or evidence on behalf of the respondent? Seeing none, thank you. Okay, members, this is time for questions and answers, collecting more information before deliberations on making a determination. Vice Chair Josh Wolf.
I'm sorry. What was your name from the city?
Ms. Buckley.
Ms. Buckley?
Teresa Buckley.
Teresa Buckley.
Yeah.
Thank you. You were describing the relationship with the student and just said it wasn't a contractual relationship in the typical sense. Was there a payment made from the city to the student?
I believe there was. I am not intimately familiar with the details of that payment. I'm sure that there are ways to investigate that, but I don't know. I haven't come with that info.
Sure. And then do you happen to know what Mr. Minardo is doing today?
No, I do not.
Great, thanks. And then, go ahead.
Ms. Buckley, just to follow up on that question, do you frequently have other graduate students or other students or people that provide similar services on a regular basis?
I have never worked with a graduate student in the normal office of
I'm not
treasurer.
talking about you, I'm talking about the department.
Yeah, so I'm pretty familiar with the actions of the department. I've been there for over 2 years, and
Yeah.
I'm pretty aware of what goes on. It's very rare. Most of our contracts involve multi-million-dollar requests for proposals that are almost completely disclosable under the laws of this body, and we frequently provide that information, but it's mostly big contracts that I'm familiar with professional vendors.
Okay, and, but from, let's say, an HR perspective, did anybody notify you or flag you about how this particular position or how this particular person would be regarded or classified with regards to working with the city well, let me ask before that, was this person working for the city in an official manner?
You mean as an employee?
Well, I'm saying if they were working on work product that could be privileged or as part of public information or what have you, there could be some specificity as to their relationship with the city, whether they were compensated or not.
I don't have the details of the contractual relationship, whatever that was, but the work product was definitely the city's product, and I believe we provided a lot of information to Mr. Warfield about the research that was conducted. I believe we sent several emails to him back then.
And was this work product, after it was finished and finalized and approved, is it a public document?
Oh, yes, it's a public document. It's on our website.
And were all the parties that were involved in creating it, editing it, publishing it, listed in that product?
I'm not exactly sure of the authorship. It's been over a year since this came
So-
up. It is a public document. You can look it up right now.
So this person that the petitioner is asking about, that person's name is printed on the document?
I believe he's credited with
He's credited.
authorship, yes.
Okay, great. And before I hand it off to Member Highland, let me just ask Mr. Warfield a question. So, Mr. Warfield, what information are you looking for? You're looking for contact information for this particular person?
Yes.
Okay, thank you.
And may I answer some of the questions? For example, the fact that everybody told me there was a contract.
Well,
I understood there was.
if you're going to rebut what she said, I'd like to wait until
Well,
rebuttal.
I would like to be asked the same questions that she is because I know something too about some of the things you've asked.
Okay, so I'll ask you, Mr. Warfield, do you know how this person was compensated and whether they were classified as an employee of the city?
I believe he was not classified as an employee. I had a hell of a time trying to get a contract. I got something that described the work to be done. It looked something like an RFQ or an RFP. I was continually searching for a signed contract, but I was told specifics about the contract, for example, that it ended the day that he presented to the Library Commission his report. I understood there was a $5,000 payment for this. His name was most certainly included in the report, although it was put at the very end of the report within the document text, and I could show you a copy of the document.
So you mentioned that there was some sort of RFP or RFQ. Is that included in your documents
No.
for this case?
No, it's not.
Is that publicly available? You said you
I
saw it.
believe it is, and it may have only been publicly available because I kept asking for the contract. I wanted to see what specifically was he being hired to do and what was he being paid.
Okay, thank you. Member Hines.
But what I got was, it didn't say RFQ or RFP. It gave an outline, and maybe Ms. Buckley knows what it was called, but it didn't look like an RFQ or RFP that I seen before. It didn't have the label. But it was given to me as the contract, but there were no signatures, there was no price. I don't believe there was a
So
due date.
Is that included in the record here?
Not here, no, it's public record, though.
But
I
you've
could
seen
find
it,
it.
you've seen
I
it
could-
before, and this is, okay,
I've seen
thank
it,
you.
yeah.
No, thank you, I'll ask more questions later. Go ahead.
I was just going to respond to Member Wolf's,
Which member? Wolf.
Josh Wolf, comment about his contact info. I just looked him up quickly on LinkedIn. Mr. Monardo is at the Unified School District. If that helps you, Mr. Warfield, in your getting in touch with him through his LinkedIn account. I know it doesn't answer what we're looking at here, but
Yeah, his email address is actually on the Unified School District's email listing, and it's MONARDOJ. So his name, last name, and then J at sfusd.edu.
Okay, so I'm going to interrupt you on this. I mean, we're not here to do our own investigation on behalf of any of the parties. The case is being presented with whatever discovery is being presented, and we need to draw from that. The issue here is why didn't the respondent provide that information to petitioner? So if we can hone in on that and continue with any other clarifications or questions you have about the case, I'd appreciate it. Seeing that, okay, Ms. Buckley, I have another question. So obviously this person, according to the petitioner, this person was hired first and he was compensated. Is there any kind of contract that is available or announcement for this particular position that they were hired for?
I recall there was some sort of inquiry to solicit people to potentially work on this project. I don't know, and I was not under the view that it was a formal RFQ. I think it was much smaller than that, but I'm sure there are documents. I don't remember getting a request for those documents, but we can certainly provide them,
Okay.
subject to whatever restrictions there are.
Yeah, I understand. Okay. Okay, thank you.
Okay.
Any other
it
questions?
seems like the crux of the matter is, their balancing act as far as what they're revealing, not revealing. Does that jive with, our charter and what we do? So maybe that's what we should focus on.
Yeah. So I see here on page 28, Member Highland, you were contacted by the petitioner?
Don't believe so. Let me take a look at that.
Oh, no, this was a message from our staff. Okay, sorry.
No, I think at the last.
You were vice chair at the time.
The last
so-
hearing, I again told Mr. Warfield that on a quick examination, there was contact information for this individual on
Got it,
the web.
okay. Well, so it's, okay. All right, any other, so I just want to note on page 28, just for everybody's edification, that our staff had been contacted by the petitioner about this. And he was notified, and I'll quote, it says, if you will recall, oh no. Oh, it says, if you will recall, you will be able to find so this is a message from our our administrator to, at that time, it was Vice Chair Highland, and it states, if you will recall, you were able to find contact information on Mr. Monaro during the hearing, email, and telephone number, I believe. Mr. Warfield wants to know what you found and where. And
He did contact me asking.
right,
After
and the
we-
response was from Vice Chair Highland at the time was https://bppj.berkeley.edu/contact.
Which I think was his news organization.
It's on page 28. At the top. Right.
Right, and in that website, it has a list and a link to Mr. Monardo. And it's one of those ones that you have to write in a box, send your question, and then he responds to you or not from whatever email address
It's
or
a
site.
contact form.
Or,
web
thank you,
form.
that's what I'm looking for, yeah, it's one of those.
Okay. Any other questions, informations, clarifications on this matter? Okay, seeing none, are we ready for rebuttal? Okay, Ms. Buckley, you're first. You have 3 minutes for rebuttal.
Speaking to the microphone.
Yes, okay. So as I pointed out at the beginning, I understand this individual was working in a limited capacity on a discrete project for the city, but he also had private email and phone information that was requested. And to protect his privacy, when the request was made for this information, our office did not believe that it was disclosable, and that's why we did what we did. We did understand that there were other methods to reach him and contact him, including in person or through other means, and as that's been demonstrated here today in our discussion. That's all I have to say.
Okay, thank you. Mr. Warfield, you have the last word. 3 minutes.
I think that it's up to the respondent to show that and to define what is a private email. This person had a contract with the city. This person was paid $5,000. This person was doing very significant work for many months, as I believe, about a year long, to produce a report that had a major impact on the library's position on fines and fees. When the library finally sprang the report on people with no preparation, no previous discussion about the existence of any such report, or even the fact that there was any work being done on the report, we had 3 days from the time that the agenda came out to look at the report, read the report, try and understand the report, look at the legislation that was being proposed, and so on. There was a huge amount of information to understand and interpret, and we wanted to know some information about where did this come from, how did this happen, who was doing the work, what were their qualifications, and in particular, I was interested in the scope limitation that was clearly present in this report. And I had less than 3 days. I tried the normal way, which is to call people up and say, I'd like some information, and there was information which is not a part of this complaint. This is about the contact information. I wanted to hear from the author, from the horse's mouth, if he would answer, and there was no obligation for him to answer. This is somebody who is doing public work with being paid public money, and there's no claim, there's no definition here. There's simply the assertion from the treasurer that this is somehow a private contact information. I have to say that there's a whole range of information that is both in the state level and in the city saying basically that there is an absence of any provision that entitles email address to be redacted from somebody who's doing public work on a public contract. 67.24 talks about contracts, and it's talks very explicitly about all the information, contracts, bids, and proposals, contracts, contractors, bids, responses to requests for proposals, and all other records of communication, and so on and so forth, shall be open to inspection immediately after a contract has been awarded. All bidders and contracts shall be advised that information provided which is covered by this subdivision will be made available to the public upon request. Even the Board of Supervisors on its website says if you send an opinion piece or any other thing to them, it is subject to disclosure upon public, and it's public information if you look at the website of the supervisors. Surely Mr. Minardo had more of a connection to do official work than just somebody casually sending in a letter to the supervisors. There's no showing here that there's an explicit exemption from the disclosure of this material, and it should be disclosed. Thank you.
Okay, members. How shall we move forward? I have a question for you, Member Martin.
Yeah.
When during the if you recall, during the complaint process, was there any request for the respondent to provide documentation with regards to contract or what have you for this
I
person?
don't think so. I don't think there was. You know, with Mr. Warfield's testimony, I mean, if I could boil this down, it is he wants the contact information of Mr. Minardo. You know, at first, I mean, just reviewing the materials, I think, in my opinion, he gets the email, he doesn't get the phone number. That's, I mean, how I see it.
Despite that, even if they had even if the contract was presented, that information could or might have been redacted by the contractor and claiming the same citation of law in protecting the information.
Right, but the way I read what's the citation is protecting is more, I mean, illustrative is the Sunshine Ordinance itself. It says home phone number, home address. When it's talking about personnel, it's analogous. Analogous, sorry. So an email address I don't see provided within that. It's not Mr. Minardo's health history. It's not his personnel file. It's an email that he's used to communicate with a city entity. The phone number, I think, is different. If it's his home phone number, I think there's an argument that the phone number does get, you know, withheld. But I think the email doesn't really fall there.
Okay. Anybody else? Any other? If there's no other discussion, is there a motion?
Yeah, I'll make a motion that the email is public, discoverable, and violation for withholding it.
A second.
So what, do you have a section of
You have to craft it, make it sound a little, yeah.
of the ordinance that we can refer to?
Sure. I'm welcome to any of my colleagues helping me out. Yeah, I think you could just say that the email does not fall under section 6254. I believe that was cited as a
6254C.
correct. It's not a personnel, medical, or similar file, which would constitute an unwarranted invasion of personal privacy, and is therefore disclosable.
Member Highland?
Didn't we have something similar with Office of Short-Term Rentals about how much and what we could, and I think we voted violation against them for not disclosing, it might have gone also addresses and whatnot, but I think it was the emails.
That was correct, because those people they were going into business, and they knew that they were going into business with, in the city of San Francisco and
Right.
filing these records. And so it
Presumption
was,
of public.
right, and it
Yeah.
was their obligation to create alternative email addresses or alternative contact information if they didn't want to present their
Yeah.
personal
Just
information.
curious to see what code we use there, because
Which case was this?
this is the OSTR, Office of Short-Term.
Oh, the
Rentals.
Sandra Weiss matter, that's, I believe,
It's the Airbnb.
95, I believe, is the number.
Oh, very good. Let's look it up. Sounds right.
Right, so, okay, so, did you come up with a
Yeah,
section?
I tried to. I said, it's disclosable. The email is disclosable. It's not protected by 60. What's the one I'm butchering again?
Right, so we're trying, if you're,
6254C.
if you're making a motion to find a violation, we need a sunshine ordinance or a California Public Records Act citation number. So for 6721, which is the petitioner is suggesting,
Yeah, in that case, it was 6721B, 6726, and 6727.
Okay.
Right, I just found that, yeah. Basically just saying that it's part of the public domain and should have been released.
so 6721B would be timeliness. 6720, you said 6726?
26?
Yes, 6726 and 6727 in that particular case.
Withholding kept to a minimum,
Yeah, it's definitely applicable there.
and justification for withholding. So the okay, so yeah, so under California Government Code 6754C, except as provided in other sections 6254.7 and 6254.13, this chapter does not require the disclosure of any of the following records. C states personnel, medical, or similar files, the disclosure of which constitutes unwarranted invasion of personal privacy. Those are files, actual records, not information contained in records. So I think that is an incorrect, I agree, I think that's an incorrect section. But I do want to, at least for the purposes of just getting the motion on the table, just to,
I think maybe then just 6721B and 6726.
well, I would just say I guess the section that I was bringing up was if we wanted to do 6727, in A, 6727A, any withholding of information shall be justified in writing as follows: a withholding under a specific permissive exemption under the California Public Records Act or elsewhere which permissive exemption is not forbidden, and the requirement from the respondent is to make a citation. Their citation on page 39 of their response letter was specifically for 6254C. And also, so that's for that particular citation. They also cite case law. City of San Jose versus Superior Court, 74 California Appellate, 4th, 1008, 1022-25 in 1999, specifically holding that the public interest in non-disclosure of private personal information, including names, addresses, and personal phone numbers, outweigh the public interest in disclosure of personal information in response to a public records, PRA, Public Records Act request. It doesn't state emails. It just says private personal information, including names, addresses, and personal phone numbers. Okay?
So how are we doing this motion?
We're deliberating that to,
State.
I think it's very similar to the Airbnb one we had. Yeah, so,
I'm just not sure that 6726 applies.
yeah,
26 or 26?
27, I think.
No, it's 67, Member LaHood mentioned in that previous case it included 6726. I'm stating that I don't think that this reaches that threshold. So,
Because they didn't withhold in its entirety. is that
right,
what-
and since the requester only asked for the information and not for the contracts, other sections with regards to disclosure of the contracts, I think it's 67.
It's
It's
just-
just 6724. 6724. E. That's what I'm looking at, 6724E under contracts, bids, and proposals. Which one were you looking at, Member Tesfaye?
There's another section that has to do with negotiations for contracts, but, I mean, if E covers it, then I think we're okay.
I think it does with regards to, as far as when contracts are to be made public and all the information that is part of the RFP process or the contracting evaluation to be made public after the review or the evaluation has been completed.
20E1.
Yeah, E1. Okay, so Member Martin, what's it going to be?
So Member LaHood, was it 6720,
21B.
21B?
That's for timeliness.
Violation 6721B, and then 67,
24E1.
No, because the contract wasn't requested.
Okay, if it had been. I see.
He was requesting information.
67, was it 27?
6727 for justification of withholding. So, well, yeah, I guess it would be A. Okay?
Yeah.
Okay, so the motion is made by Member Martin, second by Member Highland for 6721B and 6727A. Okay.
As to the email and not the phone number.
As to the,
Providing the email.
well, the email was provided No, the email wasn't, so none of the information was private. Okay, it's to the email, not the phone number. Okay, got it. Okay. Any other debate or discussion on this? Okay, shall we go to public comment? Okay, public
Just make
comment?
sure I got the motion right. This is for 6721B and 6727A as to the email having, not the phone number that was provided.
Yeah, for not providing the
Not
email
providing the email.
and not the phone number. Okay.
May I speak?
Public comment. Go ahead, Anonymous.
Hi, Anonymous here. So I agree with respect to 6721B, not just for timeliness, but I think that also you use that for completeness of response, and 6726 for non-minimal withholding, because they should have given you every part of the document except the phone number. I do want to point out that on page 33 of the record, which is page 22 of your PDF, it says that he did request the contract. So I'm not sure if he just hasn't stated that in his complaint, but it is in the file on page 33 of your record that he requested that. It also says, if you look at the subject person, the contractor, that they are a graduate student instructor at Berkeley. So maybe they are a contractor or employee of Berkeley, and even their Berkeley email address that they're trying to withhold as a personal email address, it may not, I can't know, it may not actually be a personal email address. It may be considered a public contractor or a public employee email address of that person contracting with UC Berkeley or being an employee of UC Berkeley. Now, the city paid someone to do this work, and that is always a contract under the law. I'm sure they gave them some kind of tax form. It's over the limit, and you should find a violation. And of course, none of this is legal advice to the complainant. It's directed solely at the task force. Thank you.
Is there any other public comment? Okay, I just want to make clear, let me see where I found that before. Okay, so on page 16 is the original request and IDR. And the item that is requested here for the purposes of this case it states, Dear Ms. Brown, when we spoke by telephone this morning, I understood you were uncertain whether to provide us with the contact information for the main author of, quote, long overdue, Joseph Bernardo, but would check and get back to us the same day. Then it goes on to say, consequently, this is a immediate disclosure request under the Sunshine Ordinance requesting contact information for Mr. Bernardo, including telephone number and email, any other way you may be in touch with him. As you know, the IDR must be responded by the end of next business day. It does not mention anything regarding contract or document. It says if you need to tie this to a document request, please provide a document showing each of the ways you contact or have contacted Mr. Bernardo for this library finds project. But it's a choice if you need to. So I'm not convinced that it rises to requesting an actual record, but actually it's requesting information that's contained in a record. And it could be any number of records. Okay. Anything else? Are we ready for a vote? Please call roll.
So we're finding 6721B and 6721A for not providing the email.
27A.
6727A.
27A.
Yeah, for
Pardon.
not providing the email.
Member Martin?
Aye.
Member Martin, aye. Member Highland?
Aye.
Member Highland, aye. Member Yankee?
Aye.
Member Yankee, aye. Vice Chair Wolf?
Aye.
Vice Chair Wolf, aye. Member Tesfaye?
Aye.
Member Tesfaye, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion passes.
Thank you. Please call, let's move to our public comment. It's just after 5 o'clock.
You don't want to hear item number 4 first?
Nope. Please call item number 5.
Hello?
Item
Wait
number,
one moment.
item number 5, public comment. Members of the public may address the Sunshine Ordinance Task Force on matters that are within the task force jurisdiction, but not on today's agenda.
Okay, is there any general public comment not on today's agenda?
If I may speak, please let me know.
Okay, Mr. Anonymous first, go ahead.
Good evening, Chair and members. Anonymous here. 3 issues for you today. So on November 12th, I filed a supervisor of records petition against the Fine Arts Museums because they have simply stopped providing public records since approximately last October. And obviously, the supervisor has had a lot more than 10 days to order these records disclosed. But as you remember from last December, he claims a right to not issue such orders because he thinks that voluntary compliance is enough. But this is an example where that strategy has failed. FAMSF simply has not complied voluntarily, and after 70 days, that's more than 2 months, the supervisor simply won't do anything. And that is wrong, regardless of whether your task force can enforce 6721D or not. Now, second, in certain cases, the city attorneys are making misleading statements trying to gain an advantage in some cases. For example, the Department of Police Accountability, through their attorney, represented to you in writing that the Police Misconduct Disclosure Bill, SB 1421, quote, specifically requires, end quote, 5 types of redactions, including the public interest balancing test, and therefore SFAC 6724 can't apply. Now, SB 1421 has 4 mandatory exemptions, and the public interest balancing test is a 5th explicitly optional exemption. And government attorneys should not be doing this to the task force. If they want to win the cases, they should do so according to the words of the law. But I'd like to end on a much more positive note. There's one agency and one custodian whose work is an almost ideal implementation of the Sunshine Ordinance, and that is David Steinberg of Public Works. Now, I have thrown all sorts of requests at this department, but Mr. Steinberg is unflappable. And no matter what, every single redaction is keyed to a justification. His letters of response are timely and consistent. He indicates responsive records or no records, or if and why they withheld documents for each and every item by request, and electronic records are provided as close to as possible to an exact copy in PDF form, except, of course, metadata, but we'll get there eventually. And until I get the Chief Public Information Officer that I want, the next time the city tells you that they just can't follow full sunshine, you can tell them to get a remedial course from Mr. Steinberg, because he is a consummate professional. It's not just about his superior competency. It is also important that the other custodians understand that their role exists to fulfill the public's constitutional right of access. And they should treat those rights, not privileges, with respect as he does, instead of with flippancy. Thank you, Mr. Steinberg.
Are you finished, Anonymous?
Yes.
Thank you. Next.
Hi, my name is Michael Petrellis, and I'm here to, first of all, thank all of you members for volunteering for this very important task force. I think that you're doing an amazing service to democracy and Sunshine, and I understand you're not paid for what you do, and you put in a lot of time here at the monthly meeting and at the committees, and also when you're not here at City Hall for the meetings, you're reading up on the documents and complaints that are submitted to you. So I think it's very important to acknowledge this service you're doing for the public. The other thing I want to say is we really need to have these monthly meetings aired on SFGov TV. I hope that each of you, when you talk to the supervisors and the clerk of the board, that you are saying there's public clamoring for the funds to be allocated. I believe it's about $46,000 annually to have the technicians at SFGov TV in their control booth using the cameras and all. That money would be well spent to air these meetings. So I'm not sure if it's the clerk of the board who may be able to advocate on behalf of you members, or if you need to go to each individual supervisor. But I hope you'll agree with me that at least the monthly meetings need to air on TV in this year of 2020. Thank you.
Any other public comment? General public comment? Okay, seeing none, public comment is closed. Please call item number 4.
Item number 4, file number 19015, complaint filed by Terrence Karasik against the Department of Human Resources for allegedly violating violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and/or complete manner.
Okay. Complaint Committee Member Rodman, Chair
Sure.
Rodman
So,
Martin.
If I remember correctly, this involved an employee who there was an investigation done regarding internal personnel activity, and the complainant wants to see the results of that investigation, or see the investigation. If I remember correctly, I think Member Yankee may have said, well, you might want to pursue this through another entity to get that.
Right, if I recall, it was the department where he worked that did the investigation, and the request was made to citywide Department of Human Resource, and they only had a summary version of the investigatory file. So I think that's kind of where it was left off.
There was the background is there's an investigation, I think, it's alleged that a person was instructed to falsify time records or time slips. And there
I
was
don't know that that's pertinent to,
well,
we'll let the parties discuss those details. But I think what's important is did you get all the information?
Right.
Okay, does everybody understand kind of the basis from how the complaint committee received it? Okay, shall we begin? Okay, let's have the petitioner, Mr. Karisk. You have 5 minutes.
All right. Hi, hello everyone on the task force. I have a little statement here. It's relevant at the end of this thing, trust me. I'm here not to blame anyone for their part in the hearing, but to get information into my probationary rejection as Glazer Supervisor 1. I have submitted the relevant information why I think my removal of my position doesn't adhere to the rules that are in place by the Civil Service Commission, the City Charter, and California Government Code addressing probationary requirements, which I have today with me. I believe there were errors made by individuals that prevented myself from being able to appeal or even know why this event happened to myself. I want to thank the Sunshine and Ordinance Task Force for at the very least, getting the report that should have been given to myself the day of my probationary rejection, which is stated in the California Government Code, Article 6, probationary period 19170.19180 section 19173. In my removal, there have been forms that have been modified where the appointing officer is instructed to sign and put in his title to reading authorized signature in title. The person who signed this form wasn't an appointing officer and didn't have the authority to do so. My probation which was promotional, was 6 months, but the person who calculated the end date miscalculated this by 1 day. There's an example in the DHR form 1-14, instructions that show this common mistake. My probation had lapsed by the time this department extended my probation, which was a day too late. The instructions on the DHR form state, be very careful in determining the end of the probation date. Once the probation date lapses, you cannot extend the probation. Like mentioned above, I don't want to blame anyone, but feel that I have been wronged by certain individuals that has led to a very uncomfortable and unstable work environment since that point. I'm hoping that this can be resolved to prove that I hadn't done anything wrong in my position as a Glazer supervisor and show that I clearly deserved the position that I worked hard to get. So on top of that, last Wednesday, I was dismissed from my employment from these two departments. The reasoning being for being dishonest and treatment of coworkers in the public. So if this isn't mistreatment to myself, I don't see why, how they could prove that they could release me from 15 years of service for saying I was dishonest. And that's it. I don't think anybody's here from DHR.
We'll find that out in a moment.
Thank you.
Are there any persons or witnesses to provide any facts or evidence on behalf of the petitioner, the complainant? Seeing none, is the respondent present? Department of Human Relations, Human Resources.
I sent the agenda packet to Susan Gard, who is the custodian of records over there, I believe.
Did you get a response from DHR?
No, I don't usually get responses. I send it out. They know they have to come.
Okay. No RSVP. Okay, any persons or, so note for the record that the respondent is not present. Are there any persons or witnesses to provide any facts or evidence on behalf of the respondent, the Department of Human Resources? Seeing none. Okay. Members, how should we proceed?
Quick question from Member Yankee.
Okay.
You mentioned, I think I saw in the notes that you suggested he refile his request to Public Works. Did that happen? Do you know?
I have no idea.
All right, well, before we start to get into the merits, we are missing a party, so we have to determine how we want to proceed. Vice Chair Josh Wolf.
On April 23rd, this matter appeared in front of the complaint committee. Do our records indicate whether DHR showed up at that point in time?
I believe DHR was there at the complaint committee, if I recall. When we heard the committee look.
Yeah, please in the microphone.
Apologize. The staff, it would be in the staff notes.
Well, it would be in the minutes of the complaint committee.
Yeah, I haven't had a chance to look at that, seeing that they just now realized they weren't here. But that was just what I was trying to identify, was whether they had been there. And it sounds like someone on the complaint committee does remember them being in attendance.
Did they say anything about not showing up to this? No, nothing at that point?
No, I didn't receive that indication at all.
All right.
The minutes of the complaint committee does show that Susan Gard was there, so just for the record, she did come to that meeting.
Great, thank you.
Okay, and so then, just for the point of collecting information, since we didn't hear from the respondent, what was their response there?
Well, I guess it might help to ask the complainant a quick question. Did you receive the investigatory file from DHR that they had in their possession? If you could.
You need to speak into the microphone.
Yes, they did send the redacted report.
Okay.
I did receive that.
Okay. So that was successful post-complaint?
Yes, that was
Okay.
exactly what, the first in April, I believe it was. And it was Mrs. Gard that was here, that was representing DHR at that point. She was a little reluctant to hand over the report, but since she had an ordinance task force asking her to redact all the information or names of the others on the report, she did actually hand it over.
Right. So then I guess my question would be, what information from Department of Human Resources are you still seeking to receive? Because I believe when we talked about this at the complaint committee hearing, they said that the department, in this case I think it was DPW,
Yeah, DPW.
did an investigation, has it presumably has a file on the investigation, and then summarized that and transmitted a report
Yes.
to Human Resources.
Yes.
And so because your request was directed towards Human Resources, I believe she said they only have a copy of that final report, which sounds like has
Correct.
subsequently been turned over to you.
Correct, yes. So, yeah, my original complaint went to the Civil Service Commission, which they released to DHR because it was out of their jurisdiction for the probation. And then DHR released it to Department of Public Works for, partly because of the investigation towards the time cards. Mrs. Guard, in the last hearing, said that there was no investigation done on the probation because there was nothing to investigate. She said the appointing officer could release an employee at any time during it, but obviously there was more to it with the information that I came up with the California law, government law, stating that it basically had lapsed. By the time they extended my probation, it already lapsed that date. So I believe I sent everything into Cheryl, and she has all the pertinent.
Right. So at this point, is there any information, any records that you're still seeking from DHR specifically?
No, I don't think so. I'm just waiting now. Now more importantly, after being dismissed from my employment, that I guess I'm looking just that we could settle this, somehow, some way, or I don't know how this actually works, but now I'm without a job, without everything, my pension, my medical, all for basically retaliation, I believe, into this report.
I think we kind of have to focus in on the specific.
I understand that, and I get that.
And just one thing to state, I believe there was a timeliness issue as well when we went back to when we were at the complaint. I'm reading from the minutes here that she acknowledged that she did not respond in a timely manner. So I do think there's an issue there, but as far as, I'm not sure there's much more for this particular request. It sounds like you have now what you need.
Yes, I just don't know where to go forward after this. After having does it move forward to, I don't know how this.
Well, let's just be clear what our jurisdiction is.
Okay.
So we cannot adjudicate any matters that, regarding personnel or whatever, or those kinds of things.
Okay.
We're here only to determine whether documents you are requesting that you may or may not have received or may have been redacted, whether they are public and whether they were properly responded to by the respondent, whether you received, all the documents that you had requested, whether they were properly withheld under the law or redacted, information in them was redacted properly.
Okay.
That's pretty much the limits of what we can do. Now, we've had certain cases in the past where people have requested information that pertained to themselves. And we were told by the respondent that that information is not disclosable, but they could not provide a citation that they could withhold it from the actual person that it's about. Okay, we've had those kinds of cases before. So, but the question here, correct me if I'm wrong, is you're looking for the investigative file that's regarding your termination.
Yes.
And you're not, and nobody's been able to provide you with that.
True.
Okay.
I mean, DHR, sorry to interrupt, but it was 4 years after my rejection from my probation that they actually handed me over my file.
Okay, and so was the termination, was that part of the issue in that
Yes.
from 4 years ago?
Yes, when they removed me from my probation was in actually 2015.
Oh, that was for something else?
Yes.
Okay, so, but that's different. We're talking about now. So with regards to so let me ask you this. Did you request to see your personnel file?
Yes, and I have received that.
You have received it?
I have.
Was the information you were requesting from DHR, was that included in that file?
The first time, I don't believe so. I just requested it 3 weeks ago again, before when this department put forth their actions to say that they were going to.
Have you received the information you're looking for?
You're
looking for the investigative file, right?
Yes, correct.
Have you received that?
No, not really. I'm sorry. I mean, I'm a little flustered here.
That's all right. Take your time.
I did receive the report from DHR into my removal from my probation. I did receive that, but it was 4 years after they actually it had happened, but I did get that information correct, but not timely, no.
Not timely. Timely meaning when? When were you expecting it?
Well, in the California, let me go over this real fast again.
Sure.
California Government Code Article 6, probationary period, 1970, 1980. I have it right here, actually, this.
So, but that's for the probationary investigation,
Correct.
right? Is that what you were requesting this time?
That was most of it, correct, I'm not requesting anything I don't believe anymore, other than,
Mr. Katz,
Go
you
ahead.
received what you asked for, correct?
Yes, correct.
Okay.
Yes.
And they didn't provide it timely?
yes, correct.
Okay.
Okay,
That's basically, yeah.
okay.
And
So-
I think DHR acknowledged at the committee meeting that they did not.
They
Okay.
said they weren't timely.
Okay, fine, all right, so, I want you, the complaint committee folks to kind of lead on this, since you have the most information about it, and because the respondent isn't here, you were present when they were there, if you can help
Right.
the rest of the task force out here.
Right,
with-
so what DHR had was the investigative report.
Okay.
That they did not, at that time, turn over. It sounds like subsequent to our committee meeting, they turned that over.
Okay,
So it sounds to me as if everything that DHR had at the time of our complaint committee meeting, they have now since turned over to the complainant.
okay,
But not timely.
okay, so this is regarding timeliness.
Yes.
But not fulfillment of all records.
Right, it sounds like it has been
Yeah.
subsequently fulfilled.
Subsequently
Yeah.
got it, okay, great. Okay, thank you, Mr. Karas.
Okay, thank you.
Appreciate it. Okay, any other questions, discussion on collecting discovery? Okay, seeing none, should we move to rebuttals? Okay, we'll note that the respondent is not here for any rebuttals. Mr. Karas, as part of our procedure, you have 3 minutes for any rebuttals. Since the respondent isn't here, it's up to you whether you have anything else you want to say. You'd have to come up to the microphone to say it, though. Please start the clock.
I think I explained everything as badly as I could, but, yeah, I just hope that, I guess there's justice in the end of this whole thing. I do, because I feel like I've been wronged every direction since that point. And from that point of my rejection, it has been nothing but disciplinary action against me, very frivolous, and I know that may not fall into your guys' category, but I just wanted to say it anyways. Thank you.
Okay, thank you. Okay, members. Is there any other deliberation, or is there a motion?
Sorry, go ahead.
I was going to say, I think in my opinion, we're looking at a timeliness violation and obviously a violation for them not sending someone to this hearing. That's kind of where I'm at.
Is there a motion?
So I would move that there's a violation of 6721B for timeliness and 21E for failing to send an authorized representative to this hearing.
I'll second.
Moved by member Yankee, second by member Martin. Any discussion? Public comment? Any public comment on the motion? Hearing no public comment, are we ready for a vote? Please call roll.
I just want to be sure the motion 6721B for timeliness and 6721E, is that correct?
Right, for
Yes.
not sending a representative. And you could also note that not sending a representative is also in violation of our procedure. I don't know if you want to take that, you want to add that? or
I
not,
think
but
it's
just-
clear in the
Okay,
code there.
very good. Okay, call the roll, please.
Member Yankee?
Aye.
Member Yankee, aye. Member Martin?
Aye.
Member Martin, aye. Vice Chair Wolf?
Aye.
Vice Chair Wolf, aye. Member Tesfaye?
Aye.
Member Tesfaye, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey?
Aye.
Member Hinsey, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. Motion passes.
Thank you. Please call next item.
Item number 6, file number 19061, complaint filed by John Hooper against the Office of Economic and Workforce Development for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and/or complete manner.
Okay. Member Chair Martin.
I think there were two. Per our procedure, we said we'd decide here whether to combine them.
Oh, okay, so you want to do something procedural first?
No, I just want to
Oh.
give you some background. There's two here that he suggested, I think, complainant suggested to maybe combine them, and we can decide.
Okay, well, that's a procedural matter, so let's deal with the procedural matter first.
Okay.
What was is there a recommendation from the complaint committee? Did you use the kind of the test to see if they can be combined?
I mean, I think they can.
Well, wait a minute, they're two different departments.
Yeah.
No, we can't combine them.
Are you referring to the ones that are on this agenda? Because they're against two different departments.
I am referring to the ones that are on this,
On this agenda? Okay.
but if it's
Yeah.
two different departments, we obviously.
Yeah,
Yeah.
no, we don't, not from the same, if it's the same petitioner against the same department for multiple violations that are similar, then we can combine them, but not against separate respondents.
Yeah, so I mean, I think this first one involves, I think of it as the Survey Monkey one, where you want to know exactly, not just the results of the survey, but how people responded and kind of the internal data that comprises the survey. I'm sure I'll be corrected if that's not the case. But, and what are they providing? They're providing the results of the survey or how that's working, if that even exists. Okay, and I think there might be a contractor that was involved in doing the survey, that's not the city entity, and do they still have those survey records? And
So is this for completion or delivery of records or withholding records,
I think
timeliness?
it's completion of delivery, and is essentially one department saying, listen, we've given you what we have, if I remember correctly.
Okay.
But there's a belief that there's other records out there, if that
So
makes
some
sense.
records were received, but there's a belief that there's other
There's a
records.
belief that there's other data and records out there.
Okay. All right, anything, other members of the complaint committee, anything to add?
I wasn't at that one.
Okay. All right, okay, let's begin. Mr. Hooper, petitioner, you have 5 minutes.
Good afternoon, Mr. Chairman and members of the committee. Thank you for this opportunity. When I appeared before the Complaints Committee last August, I left under the impression that the complaints had been combined. Obviously, that's your decision, but the reason that I named both DPW and OEWD is that from a member of the public's point of view, it's very hard to really know who has the records and should provide them. DPW has a full-time employee in this matter called the Green Benefit District Administrator, and OEWD handles the contracts and the transfer of money. So I have to confess that my mention of both agencies had to do somewhat because I don't really know where the responsibility lies. So as far as I'm concerned, it's perfectly fine to treat this matter as one, and then you don't have to call me up again. Anyway, I've got a written statement which I think would go over the time that you want, but I'll submit it for the record if I may, and I'll just make a few summary remarks. So, as you know, this matter concerns something called green benefit districts, which is a city-funded project to convince neighbors in various neighborhoods to tax, property owners to tax themselves for additional basic services. And over time, I filed a Public Records Act request, which is part of your record, in February of last year with 9 detailed questions. And having failed to receive the answers I was looking for, I filed a complaint with your board in May. And so the question, I think the principal question before you is, on what basis do I believe there are additional records which have not been disclosed? And I don't know if it would be timely to hand. I didn't make enough copies, but I made almost enough for you. I've only recently come upon the addendum to a lease between a contract between OEWD and the nonprofit contractor in question, which is the San Francisco Parks Alliance. And that addendum is a list of tasks and deliverables, as it's entitled. There are 31 of them, and they require that certain things be done and then that certain reports be made back to the city. I'm sure you're familiar with that, more familiar than I am with that format. In any case, what struck me when I came upon this addendum to a July 1st, 2018 agreement between the city and Parks Alliance is that the tasks and deliverables mirrored very closely the questions that I had originally asked about the process. How is it funded? How is the city involved? How are surveys done? How are they interpreted? The whole range of things that the public has not had a right to know, and yet we're talking about hundreds of thousands of city dollars. So I included that, I think it's 8 pages, the 31 deliverables, in my longer statement that I'm submitting to you today for the record. And it seems to me maybe the easiest roadmap for the city agency, whether it's DPW, where there's a full-time green benefit employee, or OEWD, which is also very involved in the process, for one or both of those agencies to simply take that list of deliverables, which is part of the contract, and give the public the answers to those 31 give us the deliverables, which are the city's required responses, most of which we do not have available to us. So, Mr. Chairman, with that, I'll noting, please, that I'd like this in the record. I'll take questions or proceed as you wish. Thank you.
Can I just ask, what is it that you're providing us here?
I'm providing a summary or I'm providing a statement which I decided would be longer than you might tolerate today. It gives you some background on the whole green benefit process.
Was this included in the documents that you sent for the record?
Say that again, excuse me, Mr.
Was this included in the documents that you sent our administrator for the record?
No, this is new information which
Okay. So, members, please collect this back. We have, during our complaint procedure, there are timeframes for delivering materials, and new information that is provided would have to be approved by the members here, and that would take time to do that. If you feel strongly that this information should be included in the record, I'm happy to continue this matter and re-refer it back to the complaint committee for their review, and whether the information is, compelling enough to be included into the record or not. It's up to you.
Well, my answer, Mr. Chairman and members, is absolutely. This is critical information to your understanding of the existence of the records that I've been asking for almost a year. So if the procedures go back to complaints, I'm happy to follow your instruction. But absolutely, the information I submitted today is probably the most important that I've been able to come upon in a year of looking for it.
Okay, because we're not going to spend time here to read through the document. because it seems pretty, extensive, and because we have other cases.
I understand that,
we've
Mr.
been waiting a
Chairman.
long time for, so.
No, I completely understand, and I understand your time constraints, but if that's your pleasure, then I'll certainly follow that, but
Okay, we're going to continue with the hearing procedure. We'll come back to that procedural part after we hear from the rest of the parties. Okay, thank you.
thank you.
Are there any persons or witnesses who provide any facts or evidence on behalf of the petitioner, the complainant? You have 3 minutes.
Turn this on.
Members, please look at your monitors.
Mark Sullivan. Hello. Public money was spent for a survey and engineering report under this contract. Public records that have existed under previous contracts and should be under public under this contract are invoices and the amounts spent from the survey company and engineering company and the contractor SF Park Alliance. The end products exist, but the invoices have not been made public. Of the records that have been made public, they show agendas, minutes, and other records on a Google hard drive set up by the contractor. One of the records that is public shows an email thanking Jonathan Goldberg, a city employee with the job title at the time, a Green Benefit District Program Manager, being thanked for the detailed minutes. The document is on your screen. These minutes are not public, and logically they were given out by Jonathan after the meeting, possibly by email. The respondents claim previously that these records that we request do not exist. Since we cannot ask the respondent direct questions during the hearing, it is up to the Sunshine Ordinance Task Force to probe in order to protect transparency. Why do these records not exist now when there are records that show they did exist? Who determined or made them not available? Can a contractor with taxpayers' money determine what records are public? If government officials and employees can claim the records do not exist during an inquiry, where is the evidence that they have, where they have existed? It undermines the whole purpose of the open record laws. Record retention is just as important to the public right to understand what their government is doing. Open record laws are meant to prevent backroom deals and have a public discussion on the merits of ideas and transparency on how those ideas are being put forward and taxpayer money is being spent. Thank you for your time.
Thank you. Are there any other persons or witnesses to provide any facts or evidence on behalf of the petitioner, the complainant? Please come up.
Good afternoon, members. My name is Lillian Steelstra. I live in the Inner Sunset. You asked for facts and evidence. A little bit of this is maybe some paranoia on my part or my conspiracy theory way of thinking. A few years ago, a green benefit district was proposed in the Inner Sunset. A few vigilant neighbors went and requested for public records, asked for all information pertaining to this project, and we received plenty of information. We got down to emails saying, I'll meet you at what time, I'll have this coffee with this person. All the correspondence that ever went on that had this particular project in place, the Inner Sunset Green Benefit District. It was very helpful for those of us in the neighborhood who wanted to know the inner workings. And from there, we were able to figure out, what was the strategy? We managed to then compile a letter to other residents in the neighborhood, and we were able to persuade people not to go ahead with this project. This project in the Inner Sunset subsequently is on hold currently. And this conspiracy theory comes where one of the current members of the Green Benefit District proposal group in the Mission Dolores district was a consultant to the Inner Sunset Group. And the consultancy was at the end of the Inner Sunset project. There was another proposal in the Buena Vista district. Similarly, neighbors there requested information, got a lot of information. Now, what I'm thinking and feeling is that the Public Works Department, the people involved in this project are realizing, oh my God, we better not say anything on email anymore. We better not have any records anymore. We better not, oh, I don't know, share our coffee plans with our neighbors anymore. So it's a little bit of paranoia on my part, but judging from the information that we have requested from the Mission Dolores Green Benefit District, the quantities are vastly less. And that's just my little bit to add to this saga. Thank you very much. 19 seconds to go.
Thank you. Are there any persons or witnesses providing facts or evidence on behalf of the petitioner or complainant? Seeing none, respondent? From the Office of Economic and Workforce Development.
Yes, good evening, Chair, members of the Commission. My name is Mary Ann Mizuko Thompson, and I am the custodian of records for the Office of Economic and Workforce Development. A couple of things I'd like to clarify. I have provided Mr. Hooper and Mr. Sullivan with all of the emails and all the data and all the information they have asked, to include what he's referring to as a document of deliverables. And I would like to be abundantly clear. We, in doing an audit in our accounting systems, found where the Parks Alliance had submitted their deliverables. And I sent this in an email to Mr. Sullivan, Mr. Hooper, and Cheryl, explaining that we found these documents post the original request and once we closed it out. And having integrity in our work product, we provided them to Mr. Hooper and Mr. Sullivan voluntarily with transparency and sending those documents to Cheryl. We've provided every document, and we're here tonight because what Mr. Hooper originally asked for was the data from a SurveyMonkey. The data from the SurveyMonkey was provided to him in an Excel spreadsheet because the data has to be provided in a deliverable content way. There's no way the SurveyMonkey drops into a spreadsheet. He has been given all of that content and all of those documents, and we have nothing more to give. Thank you.
Thank you. Are there any persons or witnesses providing facts or evidence on behalf of the respondent? Seeing none, members? Member Martin?
Get back to the threshold issue of the whether or not to continue with the packet.
Right. So it seems to Mr. Hooper has provided some information that he feels is essential for being able to make his case. Considering our rules, we cannot take that information here during and after that deadline. How shall we proceed? The question is do we continue the item and send it back to complaints for review, or have you? I'm not interested in spending the time to go through all of it and then having him explain how it is should be added.
No, I would agree. I think it's a lot to digest at the moment, and if it's as critical as he says it is, I don't think that's fair to the surprise of the respondent or to us. So
well, the remedy for at this point for either party is depending upon the outcome. If we find a violation or not, they will have a reconsideration process that they can invoke.
If we took it on to.
If we no. If we don't take the information today, and let's just say we don't find a violation, then the petitioner can file for reconsideration, and then re-enter whatever information he has that would be, he or she feels is new information that we find compelling enough to, that would change the outcome.
Yeah, I mean, in consideration that I would make a motion to continue the matter to to a complaint committee with the new information.
Okay? Is there a second?
Second.
So moved by Member Martin, second by Member Highland. The motion is to continue this item, re-refer it back to committee with, to consider the new information into the record. And then we'll, when we come back, you'll provide, the complaint committee, chair, you'll provide a report as to how this information will applies and moving forward. Because we're here right at the point of collecting the information and as it is pertinent. Okay? Is that clear? Great. Let's take public.
Who seconded?
It was Martin Highland. Any public comment? This is a motion to continue. Let's take a roll call. Yes, do you have a question?
No, I am just going to object to this procedure. If Mr. Hooper has a issue with documents that he says I didn't give him, he should sunshine me again. And if I don't give him those documents, or if I can't prove that he isn't already holding those documents, then I think we should come back again.
It's our prerogative to make this, to adjust this procedure, because if any party brings new information after our deadline and wants us to consider that to be part of the case that is before us, then there are two roads to this way. One is we can reject it, continue with the case. If it doesn't, if it doesn't find in favor for one of the other parties, we have a procedure for reconsideration, considering that the information was provided at the very beginning of the hearing, not in the middle or towards the end. We have the option to continue the item and send it back to committee. It's our decision.
So correct me if I'm wrong, did he not have until Thursday of last week to present these items to you?
He did.
And did he?
No.
So in my opinion,
I don't know if but I don't know if he had this information prior to last week.
he's had these documents.
I don't.
Right.
We don't.
But
know
I'm just
that.
saying he had until Thursday to present these documents to you, and he didn't do it in a timely manner. And if this was me, I would be held accountable for not doing it in a timely manner. So I feel like we should close this one out.
But ma'am,
I'm willing to come back for a whole other item.
Ma'am, he is not subject to the Sunshine Ordinance, except for the procedures for requesting information. And for our complaint procedure in providing information into the record, yes, both parties have a deadline. But if information that a party wants to make part of the record before the case even begins, that's why I rejected it being introduced, okay? And I've asked the body whether they wanted to include it or not. If the body decided that, no, we don't want to do that, then no motion for continuance would have been made.
May I ask the city attorney for his opinion?
No, because that's inappropriate.
Okay, I'm just saying that if I hadn't provided those documents in a timely manner, which Mr. Hooper could have done by Thursday, I don't understand why this is being continued. I think it should be closed, and then a new case should be created. And I'm totally amenable to that, since that seems procedurally more accurate.
How is that any different than us referring it back to the complaint committee as if it was included then? The complaint committee will decide whether to include it or not.
So Mr. Hooper didn't sunshine me asking me if I have any of those additional
I
documents.
don't know what
so-
is in that document, ma'am, so I'm not going to continue down this line because we don't have any information that you may have. It'll be taken up at the complaint committee. You can take it up there at that point. This is a very inappropriate because you've stepped up. I've allowed you to give you time. I'm going to have to give Mr. Hooper time.
Absolutely.
Also, that takes away from other people's cases also, okay? And it's irregular for us to do that, okay? So I'm willing to hear your concern about this. I'm not the only person here, okay? There are 7 other members, 8 other members here, and there's a motion on the floor. We'll take public comment, and then we'll find out if there'll be a continuance or not.
Thank you.
Mr. Hooper, I'll give you a few minutes if you have anything you want to say with regards to this. It's irregular for us because we don't take public comment on our motions from the parties. But go ahead.
Well, very briefly, Mr. Chairman and members, first of all, the new information, the tasks and deliverables that I mentioned before, were not given to me by the city. They were provided to me by another member of the public who had submitted another different Public Records Act request. And I only received them recently. But I also would like to add that at the August Complaints Committee meeting, the representative from OEWD handed me a large packet, which I probably should also submit for the record, which turns out upon examination, I only got it while I was standing at the Complaints Committee hearing, is totally irrelevant and obsolete information, over a year old, that was of no use whatsoever.
Okay, thank you. I'm sorry, I'm not abridging what you want to say because I'm giving somewhat liberal time to everyone. I don't want to get into the merits of the information per se. I'm going to allow the complaint committee to make those determinations, and then the complaint committee will vote on what documents will and will not be included in the record at that point.
That's fine, Mr. Chairman. That's totally acceptable. Thank you.
Okay. Now I'll take any other public comment other than the parties and other than those who spoke earlier on behalf of, because they are now considered party to the complaint now. Any public comment? Seeing no public comment, are we ready for a vote? Any other debate or deliberations? Seeing none? Okay, please call the roll.
So this is a motion to continue and refer back to the complaint committee.
Right, to consider
New
the
evidence.
inclusion of new material.
All right. Member Martin?
Aye.
Member Martin, aye. Member Highland?
Aye.
Member Highland, aye. Member Yankee?
Aye.
Member Yankee, aye. Vice Chair Wolf?
Aye.
Vice Chair Wolf, aye. Member Tesfaye?
Aye.
Member Tesfaye, aye. Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey? Aye. Member Hinsey, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion passes.
Okay, please call the next item.
Item number 7, file number 19062, complaint filed by John Hooper against Public Works for allegedly violating Administrative Code Section 6721 by failing to respond to a public records request in a timely and/or complete manner.
Okay, Member Martin.
Same issues, different entity.
Okay. Mr. Hooper, 5 minutes.
Mr. Chairman, members of the committee, John Hooper, I don't have anything further to add. As we've discussed, I think these two issues may well have been combined at the complaints committee level, and I think it's perfectly legitimate for you to consider them together. So I don't have anything more to add. It probably seems logical to send this one back as well.
Okay, are any persons or witnesses provide any facts or evidence on behalf of the petitioner, the complainant?
Mark Sullivan. Hello. I read Mr. Hooper's asked for records and request for records, and it was has been blanket request for records. It's not just specifically to the survey monkey survey. The one thing that hasn't been turned over, which should exist, is the invoices for, the engineering company, how much money has been spent under this contract and to where it's been spent. There are minutes and stuff that the contractor took, which is in the deliverables, which there's open records saying that they exist, and those have never been turned over. But that's it. Thank you.
Are there any other persons or witnesses providing facts or evidence on behalf of the petitioner or the complainant? Seeing none, respondent, Department of Public Works.
Hi, good evening, Chair Wolf and members of the task force. My name is David Steinberg, and I'm the unflappable custodian of records for San Francisco Public Works. Actually, first, to Mr. Sullivan's point, in Mr. Hooper's request, there was no request for invoices. You can see what the request is in the documents. I won't take up too much time because I believe this is fairly straightforward. We turned over all of the responsive records sought by Mr. Hooper that were in our possession. Mr. Hooper says that we should get copies of additional records from the San Francisco Parks Alliance, and that's sort of the crux of what his complaint was. Because that group has a contract with the city, Mr. Hooper knows, however, that this contract is not administered by Public Works, but by OEWD. In fact, as noted in the Deputy City Attorney's memo to the task force, the complaint and subsequent communications from Mr. Hooper actually refer to OEWD specifically and not Public Works. Finally, the full task force voted unanimously in August to find that Public Works did not violate the Sunshine Ordinance on a virtually identical complaint by Mr. Hooper's associate, Mark Sullivan, who just spoke. Consistent with that order of determination, we ask that you find Public Works did not violate the Sunshine Ordinance in this case. Thank you.
Are any persons or witnesses providing any facts or evidence on behalf of the respondent? Seeing none, members?
I have a question.
Member
When Mr. Hooper spoke, and maybe I should direct this to Mr. Hooper, if you don't mind standing up to the microphone. When you started speaking, and I know that our chair has said that these cases cannot be merged, were you expecting that the information you presented would carry over to this case?
Yes, I would, and only because it's hard for a member of the public to distinguish where the lines of jurisdiction go. DPW has a full-time employee in charge of this program. OEWD handles funding, and so not knowing the answer to where the proper responsibility for the answer to the question lies, I named both agencies. So I would expect the material I submitted to pertain to both of those agenda items.
So I would say to the chair, I think we need to deal with that before we proceed with anything else. I'd like to make a motion to continue this and send it back to committee if we're to be considering the same information that was presented, be past the deadline, but is presented for consideration with this case as well.
I'll second that motion.
Okay, I'd like to ask if before we move ahead with that, I just have a question for the respondent. I'd like to make. Mr. Steinberg, in your testimony, you had mentioned a previous case involving the same topic area.
Correct.
Okay. Has the Green Benefits District process progressed since then?
I honestly don't know what the status of that particular
I asked
one.
that because the question then becomes: does your involvement, your department's involvement and status change
I don't.
with
I don't-
regards to
yeah.
the progress of this whole process?
I don't believe it so. I'm not 100% sure what the status of the GBD formation is. Marianne might know, but the thing that Mr. Hooper asked for a number of documents. We gave him everything that we had, and I think what he has been saying is, because the Parks Alliance has a contract with the city, it's an obligation on the part of the city to go to them and have them turn over additional information. And my department's main point is that even if that is the case, which the city attorney says seems to be a little gray area, it's not, my department can't do it anyway because we don't have the contract with that, folks, with that agency, that
Okay,
Parks Alliance.
considering that we haven't gotten to the meat of the case with regards to, discovery and looking at all the evidence and information that's produced in front of us, it would be hard for us to tell whether this case is similar to the previous case that you're citing, that this is an exact duplication. of.
Mr. Sullivan's case?
Yeah.
It is, I would posit that it is exactly the same, because it's not talking about the documents that he potentially has uncovered or more information. The crux of that is the same in that he's saying, we didn't give him everything. We gave him everything we have, but he wants us to get it from someone else. That was what the entire case with Mr. Sullivan was as well. And again, because we don't have a contract with them, even if you think that the Parks Alliance has an obligation to turn it over at the request of the city, I don't have the ability to do that. I gave him everything that I have.
Okay, thank you.
Which is why I asked that I don't have to go through it again.
I understand, I hear you. But I have a motion and a second on the floor before I could get that in, but I'm taking a prerogative here. Okay, so we have a motion to continue, to also include the documents that were provided for the last case to apply for this case. Is that right?
That was my motion based on what I perceived the complainant. It seemed to me when he first spoke that that's what he was assuming, and that's why I asked him the question, and he said, yes, he did want this to apply. And if we run into the same situation where this would need to be reviewed by the committee, then I think let's cut to the chase and make that happen and not have everyone stay here, if that's
Okay.
the direction we're going to go.
All right, so this is move
Record, he does say on his document.
in the microphone, please.
We can't hear.
Excuse me. For the record, he does say regarding file number 19061 and 19062.
Okay, that's fine. Okay, so it's been moved by Member LaHood, second by Member Highland. I will just add that I'd like the complaint committee to do a little deep dive into this to determine what's applicable for which respondent, and then come back with a recommendation so we don't have to spend a whole lot more time, like do as much of the discovery part as possible. And then that'll reduce this particular period of time at that point. Okay? All right, let's have public comment on the motion to continue.
Yes, may I speak?
Yes, anonymous, go ahead.
Yes, anonymous here. I think one thing that your complaint committee might want to do in that deep dive is look at 67.29-7C. That's all I had to say.
What was that citation again?
67-.29C.
No, sorry, it's 67.29-7C.
Oh, 29-7C. 67-29-7C. Okay, any other public comment? If you have not spoken as a witness, yes, this is a different case. Go ahead, come on up. Yeah, you're not party to this case.
Hello, Lillian Steelstra again. The reason we have to ask DPW is because under the aegis of DPW, there is a full-time employee with benefits, which has the title Green Benefit Districts Manager. In this instance of this Mission Dolores Green Benefit District, an interesting twist took place when the OEWD took over. In the previous two instances of the Inner Sunset and the Buena Vista, it was DPW all the way. But because perhaps management might have felt that this employee wasn't doing too well, got to and failed to, perhaps we should give the one that has been very successful at creating what is called the community benefit districts a chance to make Mission Dolores work. This is my paranoia setting in. And in the Mission Dolores in the Mission Dolores Green Benefit District, one of the proponents is a gentleman who was very involved in the creation of community benefit districts. So the twist in this particular case, and not knowing, should we go ask this department, or should we go ask that department, or should we go ask this place or the other? In reference to the earlier case where you talk about the library and whether this person received money for payment, money was transferred from one city department to the Park Alliance. And all we're asking for, or all Mr. Hooper and Mr. Sullivan are asking for, is the work product. A lot of money went over. To date now, I mean, we don't have the invoices, but Wild Gas says over $150,000. That's somebody's salary and benefits for a year. So it would be good for us to know as taxpayers, how is this money being spent? Thank you very much for your consideration, and appreciate the good work you're doing.
Is there any public comment on the motion to continue? Seeing none, we ready for a vote? Please call the roll.
Member LaHood?
Aye.
Member LaHood, aye. And who was second?
Helen?
Yes.
Member Highland?
Aye.
Member Highland, aye. Member Yankee?
Aye.
Member Yankee, aye. Member Martin?
Aye.
Member Martin, aye. Member Wolf?
Aye.
Member Wolf, aye. Member Tesfaye, absent. Member Hensy?
Aye.
Member Hensy, aye. Chair Wolf?
Aye.
Chair Wolf, aye. Motion passes.
Okay. Let's call the next item.
Item number 8, file number 19044, complaint filed by Anonymous against Dennis Herrera and the Office of the City Attorney for allegedly violating Administrative Code Section 6721, 26, 27, Government Code Sections 6253, 6253.9, 6255 by failing to respond to a public records request in a timely and or complete manner.
Okay. Okay, let's hear a report back from the IT committee with regards to the metadata issue.
Sure, I'll talk to that. So we met twice about the metadata. Essentially, our recommendation is that we consider metadata, generally speaking, as a public record, that there's not a blanket exemption that can be claimed for all metadata, and that if there's a need to redact or otherwise withhold specific portions of metadata, that should be cited. You know, essentially the same type of test that we apply to other public records.
Okay, we are picking up this, let me make sure we get in the right place here. So we're picking this up during discovery and before rebuttals, okay? So it is, let's continue with that. Are we, so based upon your recommendation.
Right, so at this point, I think what we need to figure out is the department withholding specific portions or redacting specific portions of the metadata? And if they are, what is their justification for doing so?
Okay.
So that's, I suppose, probably the good starting place for the respondent in this.
Okay. All right, is there any other questions for any of the parties with regards to the findings of the IT committee? Do you have any questions for the IT committee with regards to metadata in this sense? No? Shall we move to rebuttals? Yes? Okay. Okay, great. Okay, so respondent, city attorney, you have 3 minutes for rebuttal.
Good evening, task force members. John Cote with the City Attorney's Office. So I'll just quickly point out that you heard, during the course of this process, you heard testimony from the city's top IT experts about the very real security risk that email metadata specifically poses, and that security risk has been conceded to by the anonymous complainer here. Now, to get to the issue of that was raised from the committee regarding redactions. Now, while redactions might initially appear as an option to address the security risks posed in metadata, doing so is not reasonable. So we would frame the legal issue this poses by directing the task force's attention to two different provisions in the law. The first is 67.21L of the Sunshine Ordinance, and that addresses the production of electronic data and says that electronic data shall be produced in any form requested which is available to or easily generated by the department. The easily generated language shows that voters recognized the need for practical limits when dealing with electronic data formats. The second provision is 6253A of the Public Records Act, and under that, the exempt and non-exempt information have to be reasonably segregable. So if that data is so intertwined that attempting to extract it is in itself overly complicated or risky, then it is not required. So the question is, do we need to go further to redact security material? And the answer is clearly no. A document of email metadata is not easily generated. Because it is so inherently sensitive, email metadata redaction requires not just taking multiple steps to create a new record, it also requires a complex and time-consuming and costly process involving the custodian of records, an IT professional, and potentially an attorney. So they would have to go through each line of metadata individually to parse out the gravest security risks. So doing this for the thousands of daily emails that the city government receives, and this is something that this anonymous individual or his associates could request at any time. So requiring the city to do that would be at odds with the sensible limitations that are built into the ordinance. So for similar reasons, what this complainer refers to as non-sensitive portions of the metadata are not reasonably segregable. It is not just the burden of redacting. Anonymous is trying to claim that we are trying to make an undue burden argument when it is much more than that. If I could have just a few moments. It is the burden combined with the significant risk of human error in the redaction process, as well as the serious consequences that could result from a mistake. Now that's what makes it unreasonable. So producing this information in a format that requires exhaustive and technical judgment calls to be made regarding voluminous redactions is not required under the CPRA, and it's not required under the Sunshine Act, under the Sunshine Ordinance, excuse me. Now, to force every city office, no matter how small, to do that just doesn't pass the common sense test.
Okay, petitioner, anonymous, you have 3 minutes.
All right. So remember, today we are just discussing a specific document, and that document is on page 528 of the record, which is page 18 of your PDF. On the right-hand side is what the city attorney's office gave me after the complaint, not before the complaint. Before the complaint, they did not even justify not providing me any of the metadata. On the right-hand side is the over-redacted image. On the left-hand side is what DPW has given us in other cases, which I then voluntarily redacted. Now, as we discussed last time, metadata is like a table. It has names and it has values. And some of those names are things like subject, received, from, to, things that you've heard of. And then the values may or may not be sensitive. I agree with them. But you know one value that is not sensitive? It's the time that you received an email. Before technology, before computers, when a document would come in to the city clerk, they would stamp it with a timestamp. And we would get to know what the time that they received that record. Who knew what when? And those two things are the things you should be able to comfortably order unredacted from this document. If you go to the next page, the city's own witness, Chief Information Security Officer Maxman, proved my case because you asked him whether the names are security sensitive, and he said no, they are publicly known. If you go to the next page again, they have told you that Government Code 6253A allows them only reasonable segregation, but actually read that law. That is about inspecting records physically, in person. When you copy a record, you get minimal redactions. You get minimal withholding. And even if they can't generate MSG and EMLs, we know they can make this PDF because they already did. So what I'm going to ask you to find is that they violated 6721 for not giving me a complete response initially, 6726 for non-minimal withholding, which they continue to do to this day, and 6727 because they didn't even provide me any justifications initially. And I followed up with them twice before I filed this complaint, and they just wouldn't tell me anything. So that's what I'm asking you to do. Please let us see the names in this table of metadata, the ones that are standard. And I've even introduced into this record all the standardized names and the timestamps of receipt of this email. Common sense should tell you when someone receives an email has been public long before computers were involved and remains public today. If you go to the next page, and you can see my conclusion on page 532 of the PDF, which is page 532 of the record, which is page 22 of the PDF. Those are my explanations of what I'm asking you to find, even if you don't agree with me that the EML and MSG native formats are easily generated. PDFs certainly are. The second email has still never been provided to us, and we don't really know why that is. And I would ask, and I'm actually asking for less than I originally asked. I'm not asking them to reveal all the values that may not be security records.
Please
I'm
finish
asking
up.
for all the standardized names.
Please finish up.
And the received timestamp. And I would actually ask your chair to refer to the IT committee for verification, not the compliance committee. Thank you very much.
Thank you. Okay, members. So, our job here is to determine whether the metadata is disclosable or not. We've heard from the respondents saying that they find the actual production of the metadata to be voluminous and difficult to extract. We've heard from the petitioner that in this particular case, he's only looking for one document, maybe two, and not thousands. The respondent is anticipating that if they have to do it for this, then it's going to open the floodgates for a whole lot of others. So those kind of encapsulate basically the areas that we're needing to look at with regards to determining the metadata issue. Now, it's important for us to figure that out because this will somewhat start the process of developing a baseline as we move forward. I was unable to do enough research to find previous cases that we've had regarding metadata, but I will tell you that we have found that with regards to the production of PDFs, and this is going back to like 2006, PDFs at that time were being scanned in, making them images and unsearchable without any metadata available. And because of the findings with expert testimony, third-party expert testimony that we brought in, the city has changed the way it does that, the entire city. Unless they only have a hard copy and not an electronic copy, then a scanned image would be can only be acceptable at that point. But for the purposes of file formats like PDFs, they're all scanned in so that they can be searched, and beyond that, the metadata is available if somebody wanted to extract it. Here, the production of, as far as I'm concerned, I'm a tech professional. I do this as my day job every day. I look at metadata all day long when I'm trying to track down hackers trying to get into my system. And every one of my staff knows how to do it. They know how to, when they say, oh, I received this, is it a real email or not? I just tell them, please send me all the headers, which is the metadata from an email. They know how to do it. The least tech-savvy person in my office knows how to do it. So I'm not finding it to be a heavy lift, or I'm not compelled by the argument that it's a heavy lift or not. And frankly, if there is, if somebody needs help with IT for whatever reason, that's why we have those folks on staff in almost every single department, and we have a whole department of technology to help with regards to that. Folks get paid a lot of money to do that. Vice Chair Wolf.
The other thing that, and along with what you're saying, the other thing that resonates to me around metadata is that for the most part, with any given data structure, the metadata is going to have a similar structure to it. So this line will have something, the next line will have something. And so if you're dealing with needing to redact a particular sensitive line in metadata, you can batch do it on 1,000 emails because you can identify that this colon precedes the sensitive part. And so there may be a need to develop some new practices to deal with large amounts of metadata, but the idea that metadata is somehow not part of the document or somehow excluded from release because it could be too difficult, I think just demonstrates the need for possibly some new practices around identifying sensitive metadata and doing it at scale.
Member Martin.
What was the second citation used by responding Cote?
6253A. And 6253A, it's one line. Public records are open to inspection at all times during office hours of a state or local agency, and every person has a right to inspect any public record, except as hereafter provided. Any reasonably segregable portion of a record shall be available for inspection by any person requesting the record after deletion of portions that are exempted by law. Okay? That means even the segregable portion has to be made available after redaction. Okay? So I'm not also compelled by that statement. I don't know how it supports the respondent's position. I think this supports the petitioner's position more, actually. I will say also in addition to what Vice Chair Wolf was saying, if you were to look at the headers, this metadata in email that we're that's the subject for us here, if you were to look at that, at those headers from any number of servers, email applications, or what have you, you will see that 98 to 99% of them are all identical. They're really all identical because these are provisions that are set up by national and international bodies as being standard formats, like what the ISO, the International Standards Organization, would put out. It's similar organizations like that, and it's very acceptable. What comes after the colon? So if it says from colon, then you have the email address. Now, if that's a personal email address, somebody can say, well, that, I think that should be redacted because of these sections of law that allow for the protection of personal email addresses. That's fine. But the actual metadata that says from colon is not. That's not redactable. There's nothing that I have read in any law with regards to exempting or with redacting any information could have that removed. There's no explanation. Okay? Now, if there are in the 1 or 2% where there may be a difference between the different servers or the different applications that are being used that shows something there that might be unique to that particular application, if that were to show that there was some security vulnerability by having that revealed, okay, that's something that could be discussed. But that has not been presented here in any specificity. We've just been told that any number of headers in the metadata could be considered. That's how I'm hearing it from the respondent. And even with the security professionals, I'm not hearing that. Tell me which ones might be of some concern. Give me just an example. It doesn't have to be, just in general. Tell me, because they exist on every single email. Also, the fact that the examples that the petitioner put forward between the ones that emails that he has gotten from, or they have gotten from other departments have not been, and that's including what you can consider to be like the serial numbers of those emails. Even if you were to receive a duplicate email from somebody else or from a different day, it would have a different serial number in there. That wasn't even redacted. And I'm sure that there are IT professionals. For this one, I think it was, I don't know what department it was from, but I've gone to enough committee on IT meetings to tell you that every single department and agency in the city has an IT person. And we have this whole Department of Technology that has professionals in it. Had this been a major concern, it would have come up years ago, because this metadata has existed since the beginning of email in the mid-90s, if not earlier. So those are my points with regards to this. Member Yankee.
I'll just add, I think the petitioner spoke to it, and it's in his files. And we specifically asked the city's information security person if he knows of any security issues with the header stuff, like you said, where it literally says from or date or whatever. And his quote was, "I do not know of any security issues for releasing the headers, but yet they're redacted." So I mean, to me, I think there is over redaction. I mean, that's based on the city's own information security experts.
Anybody else? So to the other citation that the respondent provided, it was 6721. Which one was it? 6721.
I think it's L.
L. So 6721L. So I think the section that, so basically this says that the information, basically talks about information that's stored in electronic format should be made available to a person requested, which is available to or easily generated by the department. Its officers, employees, including discs, tape, printout, or monitor at a charge no greater than the media it's duplicated on. So let's take that first part. Is it easily generated? I think if an IT person would have come over to a custodian who said, I got this request, and it's asking for me to reveal the metadata on an email. Can you show me how to do that? They'll probably say, yeah, click here, and then click here, and there it is. And do that for every other email you need to do that for. That's, I don't think, is a hardship. I think that's exactly what IT desktop support is hired for. The second part is inspection of documentary public information on a computer monitor need not be allowed where the information sought is necessary and inseparably intertwined with information not subject to disclosure under this ordinance. It's not, let's see what that means here. So inspection of documentary public information on a computer monitor need not be allowed where the information sought is necessarily and inseparably intertwined with information. Oh, but that's on a computer monitor. So we're not talking about in person or in camera inspection. So that doesn't apply here. Nothing in this section shall require a department to program or reprogram a computer to respond to a request for information or to release information where the release of that information would violate a licensing agreement or copyright law. Absolutely not applicable at all. This has nothing to do with programming or reprogramming a whole computer or even an application with respect to a licensing agreement or copyright law. This metadata isn't even, it's public domain.
I think, oh, sorry, go ahead.
Member Martin.
Well, and I'm sure respondent will, I'll have a few questions, but I would imagine it's focusing on the first two lines of that, or sorry, first portion of section L. And I mean, it says which is available to or easily generated. It doesn't say and easily generated. I mean, if it's available to them, there's an argument that they, have to produce it.
Okay.
And I'm also curious as to whether the easily part to the respondent has to do with the actual production of the metadata or the tasks that are required after production sifting through the metadata. That's just a question I have. Not that it would decide anything substantive, but if it's if they think it's an onerous task, I think the devil here lies in just the redaction process that is being associated with metadata. I don't know if anyone's arguing that it's difficult to produce. I think it's the sifting through that's the real, the issue here, not that it's,
I agree. The redaction is really, that's a different ball of wax. Here we're just talking about the release of the information. whether the redaction for the number of records is voluminous, or it becomes a hardship in any kind of way. There are other provisions that cover for that, but that's not the reason that the respondent has brought forward with regards to that. There may be a possibility, but here for this particular case, we're talking about 2 records. Is that correct?
Is that a question for me? Who's the question?
I'll pose it to you, Anonymous.
Yeah, this request is about 2 email. That's it.
Okay.
It should be like 5 pages of metadata, maybe 4 or 3 pages. That's it.
Okay, thank you. Member Highland.
Since we're looking at other sources of law on this, I just wanted to put into the record that the federal rules of civil procedure, as well as the California Code of Civil Procedure, do reference this under Rule 26. So I'll put that citation in there. Under CCP section 2031.280D1 states that unless the parties otherwise agree, metadata should be produced in the form which it was ordinarily maintained or in a form that is reasonably usable. So there is some mention of this, and this is a recent article which we may want to refer to in our deliberations.
Well, we can't because it's not in our jurisdiction.
Can I have Respondent Cote?
Yes, please. Go ahead.
Respondent, can you come?
Member Martin.
Thanks. So,
Good evening.
Good evening. Is it generally the how onerous it is to produce it that the respondent is concerned with? Or is it, you know what I mean? Is it the time associated with that? It's not necessarily getting it out there if it's redacted properly. It sounds like it's just...
It's the combination of the two. So there is producing it, and Chair Wolf indicated, that's 2 quick steps. It's a little more complicated than that, I would suggest. But then beyond that, because you're dealing with, in this case, emails in their native format, you have to then convert it to a TXT file, which then you can't redact in, so then you have to convert that to another type of file that you theoretically could redact in. And once you get it into that format, then you have to go line by line through the headers. And while in this case there may be 2 emails at question, I mean, let's be very clear about what's going on here. This is a test case. This individual or the associates of this individual have dozens, if not hundreds, of requests for records of the city right now.
Is this more of like a learning process for respondent where, okay, well, maybe we do need to learn how to produce the metadata, and it's annoying and it's time consuming, but we'll get more efficient at it? Or is it something that...
I think the sheer amount of complexity involved in redacting the metadata is really the heart of the issue here, because it's not something that once an IT professional comes over to the custodian of records and says, here's how you find the metadata, end of story. It's you have to have someone with the technical expertise, skill, and savvy to then go through that metadata line by line. Sometimes for one email, you're talking 5 pages of metadata, and know what is a security risk and what is not, as well as potentially consulting with an attorney. So if you take that process and expand it for the thousands of daily emails that the city receives, that's where it becomes not reasonable.
Let me follow up on that. How is that any different than redacting somebody's personnel file?
Because you don't necessarily need to have 3 levels of review just to make a single redaction. The custodian, the IT professional, and an attorney.
For a personnel file? You wouldn't need an attorney to review what the redactions are?
You don't need an IT professional to review a personnel file.
Well, if it was, as you're stating, if it was in electronic format and it needed to be generated in a certain way, you would need to engage If people don't
If you're
print
talking
out,
about-
people don't print out personnel files, they live on the computer.
Okay.
So now they need to print it out, and they're like, I don't know how to do that. Then they'll engage an IT person, right?
I can't speak to that. That's not the issue. That's like before.
Well, that's kind of the same issue. I mean, the question here is why does an IT professional have to be engaged for this? If they show you how to export the or reveal the metadata and be able to print it out or save it in some sort of format, they show you once. You don't need to ask them every single time.
But that's not the production. That's not the redaction. The redaction is going through once you've produced that and finding series of numbers. That are IP addresses, but knowing that series of numbers is an IP address, knowing what that IP address represents, knowing where embedded in all of that text with colons, forward slashes, numbers, et cetera.
But isn't that part of the job?
I would suggest that that's not what's required under the law.
Where does it say that?
Excuse me?
Where does it say that it's not required under the law?
So as we've noted, I've cited 6721L as well as 6253A, but I would also note that this proceeding is not happening from the beginning tonight. I've also cited previous sections. We've only just entered this. Let me rephrase that. Tonight, we're halfway through the process. We're at rebuttals already. It seems that others may not be remembering all the other information that is in the public record on this, including 6253.9F and 6254.19, which deals with the issue of the security concerns relating to these documents, which is what then gets us to the issue of whether or not this information is easily produced and whether or not this information can be reasonably segregable during the course of business. So I would point back to the record from the number of other hearings that we've had on this matter, including before the entire task force and at least 2 committees.
I don't know that we, hold on, I don't know that we received, with regards to the security part of it, any documentation to show that the actual metadata would be vulnerable in any kind of way.
You've had the testimony of Michael Maxman, as well as Linda Jarrell, and the concession of the anonymous complainer himself, who has said that portions of the metadata in email headers does pose a security risk. All of that's in the record.
And I said it too. There's maybe 1 or 2% that could be unique, that could be vulnerable. It doesn't exclude all metadata.
Our office hasn't taken the position that all metadata
You
is.
redacted all the metadata.
I would have to take a look back at the document again. I don't think that's the case.
There's a screenshot of it in the record. You can look in the record that was presented for tonight, that was part of the record since when we started this case. I mean, that is the crux of this case, is what the petitioner had produced, what you had delivered to him.
Right. But your question of, we are not taking the position that all metadata across all forms is automatically exempt from disclosure. But this is specifically about email metadata. Is your question about email metadata?
I'm talking about these documents. You just said that the metadata, not all metadata, is a security risk.
Please be more specific.
You said
all
just
email
repeating
metadata?
What you said. No, you said in general, metadata, not all metadata, is a security risk.
That's true.
Okay, so you redact. If you say it that way, in that general way, then why was all the metadata redacted in this document?
Because the metadata in this document is specifically email header metadata, where there are security risks.
Well, what about other metadata?
So, for example, we produce Excel spreadsheets which contain metadata, and we don't believe that poses a security risk.
Have you ever seen the metadata from an Excel file? I mean, I would challenge you on that because that is actually possibly more revealing about what's going on in the computer, where that came from, than email.
Our IT professionals have taken the position that when we're producing documents in Excel format, specifically like spreadsheets that are showing calculations, the field that show how the calculation was made doesn't pose a security risk, and we provide that.
Okay, that's not the metadata I'm talking about.
Well, that is a form of metadata, and we do provide that.
Okay, well, that's fine. You should show the formulas because that is appropriate metadata based upon the information that's on the page. But there is other metadata that's hidden from view, but it can be made visible. Just in the same way that you did here, so that you can review it and redact it.
Okay.
So the fact that, so here's the thing. You did not provide the metadata. You did provide the metadata. You redacted it, though. Okay? So it's not that it's a hardship to produce the metadata, because you did it. Okay?
Right. Our position is we're not.
You didn't come here saying, hey, we don't know how to do it. Right?
No, that's not our position. Our position is we're not required to do it. We did it in this instance, but there's nothing under the law that requires us to produce metadata and to go through and redact it.
Okay, I'm going to withhold my judgment on that, but thank you. Okay. Member Martin.
Yeah, just for my own edification, in your capacity, in the year 2018, how many requests did you have that involved production of metadata?
I couldn't say definitively, but this instance was the first time that I've ever been aware of a request for metadata.
So this is a new field for you?
I think it's a new field for the city.
Okay.
Getting requests
do you
for this
think
type
that's-
of information.
Do you think, this is your own opinion, it's growing pains associated with producing the metadata and just trying to navigate it in general that has created some friction in producing it?
I don't know that I would say that.
Because you can produce it. You've produced it. And it just seems like, and this is my impression, you guys are just trying to figure out how to produce it. You've taken a position that you don't need to produce it, and that's fair. I mean, you might be forced to produce it. You're going to have to learn how to produce it and redact it. And I'm just curious if this is a new set of information you guys are having, or sorry, the department respondent is having to produce, and it's just not generally easy to do yet. Is that a fair statement?
I don't know that I would phrase it that way. I mean, I would certainly say that we had not been receiving, certainly in my tenure at the city attorney's office, I'm not aware of any other instance where we've received a public records request for metadata.
And now you're having to consult experts and redact it and come here, correct?
That's the position that we've been put into, yes.
Anybody else, Vice Chair?
So this is old information, but in 2006, it looks like the Board of Supervisors unanimously passed a committee report that determined that in order to protect the metadata, that the original format would be provided when requested. And this is, as best I understand it, the same issue you're referring to with the Excel document, that providing an Excel document in its original format, if requested, maintains the metadata that the requester could be seeking. In the case of an email, why, when asking for the complete email in its full original format, is this any different?
Because the document, emails in particular, can be manipulated, and the integrity of the information in the record is not preserved. For the similar reason for why when someone is asking for a document that's in Word, we provide it as a PDF, because if we give it to them as a Word document, they can go in and change it. So as you'll note,
Wait, can't they go in and change an Excel document the same way you'd change a Word document?
I don't know definitively if they can or not, but
Okay.
May I get some of the questions, if I may, please?
Sure.
Well, somebody wants to start that ball rolling, so somebody want to ask anonymous question, so you can start that ball rolling?
Anonymous, yes, if you'd like to respond to some of what you've heard.
Sure. So I'm just saying this because I think rebuttal is supposed to give the public the chance to have the final word. So I'm going to respond exactly to what Vice Chair Wolf asked, which is, it's exactly right. And in some ways, the metadata is more dangerous in Word and Excel documents because I can see the entire history of everything you've ever done in those documents. So I think the city should look into whether they are giving the right information in Word and Excel. And with regards to the first question you asked, I think it was Chair Wolf, and apologies if I forgot who asked, it's, maybe it was Vice Chair Wolf, it is absolutely the case that once they come up with a policy or DT helps them or whatever it is, there should be a batch way of doing this because always certain values will be, and I will concede that they are security sensitive, but the names and a lot of the values, including the timestamp it was received, an email was received, should just not be security sensitive. And they can use a kind of a pattern approach, and they have to kind of get to that point where they are able to do this efficiently. If you have any other questions, please let me know.
Anonymous, a question for you. Isn't it also possible to, if you like, limit or turn off a lot of metadata at the beginning so that you're not running into these problems? I mean, can't you, since you seem to have expertise in this area, can't you set your systems up so that they're showing a minimum of information?
Sure. So the city of, I believe it is Long Beach, and I have not entered this into the record, so you may want to disregard this, but the city of Long Beach in their, maybe it's Seal Beach, in their public records, like their good government guide, they advise their departments, metadata may be disclosed as a public record, so you should configure your systems such that if it's not necessary, if you don't want to keep that kind of information around, you shouldn't retain the information, then you don't have to disclose it.
I will say, having set up a lot of email servers, it's at the server side that you can adjust what headers go in and out, but generally it's somewhat difficult because if you do that, then the delivery of those emails may not happen because the servers need certain metadata in order to know, first of all, is it coming from the right, the originating party? There's all kinds of like questions or queries that it asks so that it can handshake this within like milliseconds or nanoseconds that it's meant for the person or it's a proper email for delivery. I guess what I'm really struggling with here is that since the inception of email and knowledge of metadata in this format, that this issue has not come up before. It obviously has not been an issue to the city. And there are plenty of tech professionals in the city that know about this. I mean, intimately. So I'm just finding it interesting that it hasn't been in the, 30 years or more that the internet has been with us, that this hasn't come up, and that there hasn't been a policy that exists even in the city with regards to that as global. In the trainings and the Good Government Guide, I'm not sure that a whole lot of time is spent on metadata, if at all. And so I'm a little concerned about that in general, that if this is now becoming such an issue, that why has this not been brought to anyone's attention? I mean, obviously, there was some issue with the Board of Supervisors. They took it up, but not on email, but on even more vulnerable files, right?
I mean, I'm having a hard time identifying it, but it looks like there was a rule that said that that the Board of Supervisors approve that if you request a document in a format, that you will be provided it in that format in order to preserve and protect the metadata.
Right.
And I don't see how that wouldn't extend to the complete email document as well.
Right, exactly. Now, the question, if it was provided, let's say in an EML format, and the metadata was all there, but it was not necessarily revealed by the custodian when they delivered it to the requester could then reveal the metadata. They can, because you can't just, you can open up an EML file into a standard text editor. You'll see all the characters and everything like that, or you can import it into a email client, and then it'll remove all the extraneous characters and just, you'll have the pure metadata headers. Either way, the information is still there. It's part of the complete record. So we're focusing on these two particular, this one document. It seems to me from Anonymous that the second document hasn't been delivered at all. Is that correct, Anonymous?
They've given me only the usual body. They never gave me the email headers. They clearly have the email, though. Yeah.
Okay, so it was incomplete.
Correct.
Okay. So that's what we're here focusing on, those two documents. How it extends to other documents or other file formats, I think that's a discussion for another day. We're here on a complaint with regards to very specific documents and information, and I think that that's where we should maintain our focus. Okay. Is there any other questions, information do you need from the parties? No? Okay, should we move to rebuttals?
I think we did.
Oh, we did rebuttals. Okay, I'm sorry. So a motion.
Well, all right. I'd move that at a minimum, that there's a violation of 6726, which is withholding kept to a minimum. And I say that because the city's own security expert said that they do not know of any security issues for releasing the headers. And an example we were provided, the headers were redacted. So at a minimum, I see a violation of 6726, but I'm open if anyone wants to add to that or.
Was there a timeliness issue, I thought, early on?
No.
Oh, no.
Well, 6721A, which,
I agree with Member Yankee. I know he hasn't finalized his motion.
well, 6721A, I guess that would be for the second document. Is that right, Anonymous? 6721A?
I believe it's 6721B for the second document.
Oh, I thought you said A. Okay.
Yeah, if you look on page 530.
So B is in timeliness. Oh, that's the justification.
It's on page 532. I apologize.
Yeah, justification for withholding. Okay.
532, yeah.
Okay. Okay, so on page 527, looking at the chronology from the petitioner, the IDR was made on April 24th, on April 20th, on April 24th. PDFs of both emails that where it withheld the metadata and with no justification. April 24th to May 8th, followed up twice, May 8th. Respondent replies but refuses to provide any other information, no justification. So that seems to be the crux of the 6721B suggestion.
We can, all right, I'll move then for 6721B, 6726, and then 6727.
67 what?
6727 for no justification.
Okay.
Is that a motion?
Yes, that'd be a motion.
I'll second the motion.
So moved by Member Yankee, second by Member Martin. Any discussion on the motion, members? Okay, public comment.
On the matter or just the motion?
Just on the motion. The motion for these three violations. Okay. Okay, we do. Go ahead.
Good evening, members of the task force. I'm Hank Heckel, compliance officer in the office of the mayor. Just want to make a couple comments. The chair talked about floodgates being opened, and make no mistake, that's exactly what Anonymous is up to with this complaint. This is a stalking horse for his other probably hundreds of requests to other city departments that all seek metadata and seek hundreds of documents. So the burden and the risk arguments take on a whole other dimension when you extrapolate that out from just one person and then sort of other similarly minded requesters that'll come forward in the future. Also, there's been a lot of discussion of applicable exemptions in the law, and I think Mr. Cote was correct in all of his cited exemptions. I think what hasn't been discussed is that there's no affirmative authority in the law. There's no authority anywhere cited in the record in the law that metadata, which is an entirely different beast from the normal type of public record, is subject to these broad disclosure requirements en masse. The words metadata don't appear in the Sunshine Ordinance. The CPRA doesn't require it. There's no California court case that requires it. And the city of Long Beach may have its policies, as Anonymous cited. We don't live in Long Beach. We don't have those requirements here. The city attorney's good government guide addresses metadata and does not come to the conclusion that it should be generally provided. So I think this is a huge, fundamental, and very risky shift that the task force is undertaking here with this motion. So I would just advise caution. Thank you.
I would like to say something on this motion. Michael Petrellis again. Having just listened to Hank Henkel explain that Anonymous could be opening the floodgates to more public documents getting out to the public, I totally support that. We, the public, are paying for these documents. We're also paying the salaries of these public officials who continually show up here and explain why they think something shouldn't be done because it's too burdensome, as if Sunshine is not a key part of democracy. Sunshine is integral to democracy here in San Francisco and indeed everywhere. And I urge you to reject the argument that Hank was just making.
Is there any other public comment? Okay. I just want to, based upon the public comment, I just want to state that metadata, while not necessarily specified in the California Public Records Act or in the Sunshine Ordinance, it doesn't matter. Why? Because it's part and parcel of the document itself, which is already public. It has to do with redactions. That's what it has to do. The discussion of metadata, and when we first heard this, I brought this up, that the League of California Cities has a whole section in their Public Records Act handbook. The California Secretary of State has a whole section on it on their website. And countless other municipalities have either repeats of that or have created their own policies. So to me, I suggest that if there is a concern from either party that there is maybe any concerns with regards to metadata, that there should be some discussion about policy with regards to that, either to allow more metadata or to allow less metadata, and how that applies. And I'll just close on this point. Smith versus San Jose. That is brand new, where people have to reveal information off their personal devices, or which includes their home computers and their smartphones or what have you. And that would also include the metadata from those. So when we talk about, hardship on, or how do I even pull a piece of information off my smartphone, it is incumbent upon the parties that are to provide it to provide ways to do that. People may have to be hired. There may be people there may need to be special training or what have you. But that is part of the job. Vice Chair.
I mean, you sort of peered into Pandora's box there with all the metadata that's in your smartphone. If you want to find out how many steps you made in a day, or perhaps someone else, that's being logged in your phone. Every spot on the GPS coordinates that you step is being logged in your phone as metadata. But I wanted to speak to the fact that this is being brought forward as if it's something new. I did track down the actual language of the motion that the Board of Supervisors passed, and we heard earlier from Mr. Cote that Word documents are not provided in Word format because they can be edited. But in fact, in 2006, there were 2 complaints filed with the Sunshine Task Force that resulted in an actual resolution that if someone requests a document in the original Word format, that at least when it pertains to the clerk of the Board of Supervisors, this is city law, that the original format requested is provided, which would include Word as well as Excel, because Word was the reference piece. Now, this is not necessarily exactly related to email, but it does speak to the fact that this has been going on for the better part of 15 years of debate. It's not a brand new issue.
I'd also like to add, as one additional point, that there is case law around the country around this. And for instance, one would be basically the general statement is courts in other jurisdictions have ruled that metadata embedded in electronic public agency records is subject to the same rules concerning disclosure and exemptions from disclosure as any other public agency's electronic information. Local agencies should consider treating a records request for metadata in the same way they would treat any other electronic information by providing all metadata not exempt from disclosure. Now, this is from a website called Western City that I review quite often, and the title of the article is Local Agency Electronic Media Use and the California Public Records Law. And for that particular section, it gives a citation, not for in California. I'm sorry, it's case law citation, Lake versus the City of Phoenix in 2009. Now, mind you, this article was written in 2012, 8 years ago. So, this is something where there is a lot of discussion about. I think we're on the right track here. I think if it is any kind of flag for either the public and or city government, then I think this is a good place to have that launch, so that with however this motion goes, I think this case the city should have discussions about. I think the fact that what Vice Chair Wolf had stated is already part and parcel to how we are currently needing to operate, and I think we're in well alignment with that. Is there any other debate? Seeing none, are we ready for a vote? Please call the roll.
I made the motion.
Yankee and Martin.
Member Yankee?
Aye.
Member Yankee, aye. Member Martin?
Aye.
Member Martin, aye. Vice Chair Wolf?
Aye.
Vice Chair Wolf, aye. Member Tesfaye, absent. Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey? Aye. Member Hinsey, aye. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Chair Wolf, aye. The motion passes.
Please call the next item.
Item number 9, file number 19092, complaint filed by Justin Barker against the San Francisco Zoo for allegedly violating Administrative Code Section 6725 by failing to respond to an immediate disclosure request in a timely and or complete manner.
If you'd like, I can speak to this one because it came to the IT committee. Essentially, this is an additional request that was made after we heard one already from Mr. Barker against the zoo, where we ruled that the zoo did need to turn over some records. If I recall, Mr. Barker took that ruling back to the zoo and said, task force said you need to turn over records. Here's even more records I want from you. And then the zoo basically still says no.
Never responded.
Right. So that's kind of where we are. I don't think there's a lot more new type of law to consider here. It's kind of the same issues, just more records. So
Let me just ask, are both parties here? Petitioner, are you here?
I'm here.
Is the respondent zoo? Okay, note for the record, the zoo is not present.
This is the third meeting they haven't attended.
Okay. All right, so let's start the process here. Okay, Mr. Barker, you have 5 minutes.
Great. I'm just going to kind of repeat basically what Matthew said. On August 7th, 2019, based on the testimony and evidence that was presented, this task force found that the San Francisco Zoo had violated the Sunshine Ordinance, sections 67.21, 67.27, the California Government Code 6253, and the California Business and Professionals Code 4857. In that case number 19048. Once that determination was issued, I requested further information from the zoo, and they never responded and just stopped showing up to meetings. Considering the facts in both cases are very similar, that the zoo is violating city, state, and laws and continues to violate its lease with the city, and it's really obvious that the zoo has no respect for the jurisdiction of this task force or following laws. I think it's really important that they be held accountable for completely ignoring these requests. I was under the impression with that in that meeting, the IT meeting when we discussed it, that both item numbers would be kind of listed together, and then a decision would be made to forward them on to either the DA or the ethics committee. I spoke with. We spoke today, and you mentioned that that first case has been forwarded on, or at least the process has started to forward that on to the ethics committee and commission, and I'm really hoping that we actually can forward both of these cases on to the district attorney's office.
Still have 3 minutes left.
That's all I have to say.
Okay, thank you.
Thanks.
When you step away, then I'll say something. Okay. Any persons or witnesses provide any facts or evidence on behalf of the petitioner, the complainant? Okay. We've already noted for the record the respondent is not present. Are there any persons or witnesses providing facts or evidence on behalf of the respondent? I'll let the record show that no one. There is no one. Okay, members. I just want to note for the record that looking at the order's determination of 19048, there is no referral to.
There was a letter that I drafted, and I believe I sent it to you in the end of December, referral to ethics. You may not have had a chance to. look at it.
No, but the question is I'm not seeing in the OD that the task force had ordered it.
Can I?
Go ahead.
I think we made an order of determination, and the jury was out whether they would actually comply with it.
Yeah, but there's nothing in the order of determination with regards to referral.
Yeah, I don't think we would have, since they had a position that they didn't have to, and then we made a decision. Maybe I'm confusing the.
I'm only looking at what's in the OD.
I think the confusion is that basically the narrative was, if they don't comply, then it would get sent to ethics. They have not complied, but it hasn't come back to us. It may have come to a committee because the complainant mentioned, I believe, 3 hearings that the zoo hasn't showed up at. So it sounds like there was probably committee discussion around how it hasn't happened, and the next step may be to send it to ethics. But I don't think the actual vote to send it to ethics has happened with this body yet. Does that align with anyone else's?
I just don't remember sending it to ethics.
I think it was mused about, but never fully voted on in this body.
You say this was back in August? Cheryl?
Did I send the letter to you?
Yeah.
December, end of
Oh,
December.
end of December?
Do you recall?
It was drafted, well, I have it last drafted December 31st.
Do you recall?
Oh, here, Justin Barker.
Okay.
I got
Do you
it.
recall, Cheryl, when we
Right.
might have authorized you to send that letter?
I haven't sent the letter.
Yeah.
Okay, so, I'd like to get confirmation, because this hasn't been sent out yet, from what I can see. I did respond to this. Oh, you did refer, no. No, that was for Hearts. I don't think you did for this one, because my response back to you was that it didn't use our boilerplate language. So this one's still sitting on your desk, right? Okay, so it hasn't been sent out yet. I'd like some research to determine whether the task force had actually made that referral, or whether it was just part of discussion. Because the OD on record does not show that we made a motion, and that's already been signed. And well, actually, it would have been in today's minutes, right?
This is a different case.
Today's minutes?
Oh, no, that's from, sorry,
Yeah.
that's from last year. Oh. That would have been for December's minutes, right?
I would think, since that's when Cheryl drafted the letter.
When was that case heard? All right, well, anyway, this is a kind of somewhat of a technicality. I would like just to get some confirmation about that. Yeah, or refer to the minutes. I just was a little taken aback because I was just reading all the documentation that's in front of me. I didn't see any referral, but do see the letter that you sent me. Okay, let's move on. Questions for the petitioner? Member Martin.
Yeah. So they never responded to the earlier order? They never produced any records?
The original complaint?
Right.
Or when I made the original request, they sent me, the only thing they sent me was a screenshot of some financial information, but that was like only one small line to the request I made.
After you were here?
No, that was the only thing they ever sent.
Was that before you were here?
That was before I was here.
Okay.
And so, but nothing else has been offered up.
Right, and you were here in August. We said they should give you this information, and they never gave you anything.
So when the order of determination happened, sorry, I have a young son, so everything's a little blurry. So the decision was made, the order of determination was sent to me, and then it was basically this task force asked the zoo, made the request that they present the information from that original.
Right.
And then I showed up to a compliance meeting, and they didn't show up to that. And they didn't present anything to me.
Have they presented you anything since they were presented with the order of determination?
Nothing.
Okay.
Or after in this case that's being presented tonight, this whole process was kind of new to me, so I didn't really understand that. Like if I only requested two things, those two things were only going to be presented in front of this case, or in front of this task force. So once I realized that like this task force was going to oblige them to follow the law, or at least say, hey, you are responsible for presenting these documents, I sent a much longer, detailed document with all of my requests.
And they didn't respond to that either?
They didn't even respond to the email.
And that's why you're here today?
Yes.
Okay.
And my hope is that we can, because it's been quite a process to get to where we are here, my hope is that because it's such a similar request that we somehow, I think that they're two different cases, but like combine them. And that was kind of the original conversation during that IT meeting that we had, was that we would somehow like make them put them back to back for ease. But from my understanding, I've never seen this committee make a decision, or this task force make a decision about where that first case should go.
Well, the first case has been decided, right? We said
Yeah.
they should give you the records, and we gave them an order of determination. They never produced anything.
Right.
Correct?
Right.
So now there's another order or you want them to produce stuff, and they haven't done it.
Right.
And does it involve the same data set, like medical history of animals, or
Medical
deaths
history
or
of
something?
a long list of things. I can read them off, but I think the kind of the bigger issue to me is that the zoo just doesn't think that they need to hand these documents
Right,
over,
okay.
and are refusing to.
Right.
So what are the next steps to hold them accountable?
I think to refer to the ethics and the district attorney.
Yeah. But the question is, can we also piggyback the second case, or does that have to go through its?
Well, they didn't show up. They didn't take the time to show up today, so.
Yeah,
Wait,
so let's just get clear on what's happening here. So the previous case was heard in August 7th meeting. Okay, the action for that meeting was, it was moved by Member Martin, second by Member Kanata, to find that the zoo violated Sunshine Ordinance Section 672127, Government Code 6253, and Business and Professions Code 4857. I'm a little confused by that one. By providing requested records in a timely and/or complete manner. The task force referred the matter to Compliance and Amendments Committee and requested that the zoo provide the animal care records and provide legal citation as to why the records have been withheld. Now, I don't know if this case has come back from CAC, that case has come back from CAC with any recommendations.
It looks like it went to September 24th CAC, and they made a recommendation to refer back to the full task force to forward to the ethics and DA's office. But I don't think we've
It
We've
hasn't
heard
come
it.
up, we haven't
Right.
heard it yet,
Yeah.
okay.
So I think
that-
it's in the pipeline
That's
for
in
us
the
to review.
pipeline, okay, great. So, but that one case has been already adjudicated, we have an OD on it, okay. This case is completely independent of that, okay? And so there's no combining of anything, okay? And until we hear the first case as it comes back to us for a follow-up, and if there's anybody feels the need to take action thereafter, based upon the recommendations of that committee, we'll deal with it at that time. But we're not here to adjudicate that, okay? Appreciate your suggestions for it, but we want to keep to the merits and to the subject matter of this particular case so we can get through that.
Okay.
Okay? All right. Any other? Yes, Vice Chair Wolf.
It seems to me that given that we have a situation where the zoo has stopped responding with the task force and stopped engaging the respondent, we have one case that has worked its way to be referred to this task force to possibly send to ethics. We have this case that is vaguely similar in that it's both a request for information that the zoo is saying is outside of their what they need to comply with, whether they're the same information or not. It seems to me that we should note that the zoo isn't here today, continue this case to immediately go alongside the one that's already been referred to ethics, and presumably at that point in time refer the existence of the totality of the information requests, the totality of the non-responses to ethics or the DA as is determined. Earlier, you spoke of it being referred to ethics and then said you wanted to refer to the DA. Do you have a thought on ethics versus the DA? I know for myself, I haven't really figured out how they land at the end of that point. You may be in a similar boat, but I'd love to hear your thoughts on DA versus ethics versus both.
I mean, this process is new to me. I'm just under the impression that we have an entity that is partly, that the city gives $4 million to every year, and they are just basically not showing up to these meetings and not following through on their obligation, both in the lease and in the law. So I really think that the DA would be a better way to go to move forward with it in a legal way, because it doesn't seem like a recommendation from the Ethics Commission will do much, because clearly what's happening here hasn't done much. So my hope is that the DA would be able to take the case at least, and that's my hope.
I would just like to advise that I think it's a little bit of a slippery slope to have that discussion, because the referral to the DA is under very specific sections of the Sunshine Ordinance versus ethics.
I only asked because he invoked both of those two entities in his statement.
Yeah,
So
but
I was
it's
asking
still-
for clarification for why he brought it up.
Oh, okay. Okay, that's fine. But you asked him if he had a preference.
I asked him his thoughts on, he brought up both.
Okay.
Where was...
All right, I just want to caution that, we need to be careful about presupposing which one it should go to based upon a discussion with one of the other parties, because we have to first find what the violation is. The violation will determine.
I absolutely agree. I thought perhaps he was prepared with a criminal element of how this broke, and that's
Okay.
why he invoked the DA, or
I see.
he very much and mentioned it in passing, and I really wanted to hear if there was more to it than just it's one of the two places we can send things.
Okay, thank you. Anybody else? Member Martin, do you have something? Okay.
I think I'm getting confused that there's two. You have two
Yes,
cases.
there's two cases,
So
yeah.
the first time this one was brought before the task force was at the information technology.
That was where the complaint was heard
This
at.
one.
This one was heard at.
And then your other one went through compliance amendments, and now it's floating
whole
there.
series of.
Yeah,
What did it
let's
come back?
let's
Okay,
not
I just wanna-
discuss the other one, because it has nothing to do with this one.
Right.
Okay, this one stands on its own merits. Whether it involves the same set of documents or not, he's asking for other information that was not asked in the first request. And so that's what's happening here.
They haven't responded at all.
Well, they said that I believe it in the minutes from at the complaint process, Mr. Barker stated that this request is that the zoo claimed the request was overly broad and voluminous. Is that correct?
In my original complaint?
You know, this
complaint. This is a new complaint.
Right. I think I might have been referencing an email that was sent to Cheryl. Because I think in response to that, because that original email, so basically what I did was I sent this complaint through email and CC'd Cheryl on it, and then the zoo responded to it. 10 days later, you said, "Have you followed up on this request to the zoo?" And the zoo sent an email response to Cheryl, and I believe that was there.
It's on page 1082, or looks like I think it's page 20 of the PDF. And you're right. It's an email. It's to Cheryl on August 21st.
I think the more recent letter is the one from October 16th to Victor, which says basically the same thing, but then on the one, this is on page 1091. Is that right? Yeah. It says in the third paragraph, it changes a little bit and says, over the years, by mutual agreements between the parties, the SFZS has agreed to provide certain additional carve-outs, but it maintains the same idea that they're not covered by, quote unquote, the broad sweep of the Sunshine Ordinance.
But they didn't cite any code sections.
Yeah, it's essentially the same letter as previously, with the addition of discussing how that mutually they've agreed to additional carve-outs or categories of information to be shared with the public. But other than that, it's the same denial.
All right. Unfortunately, the zoo isn't here, but does anybody have any information as to what the relationship of the zoo is with the city? Is it an independent contractor?
There was a lease that was produced in the prior case that we looked at.
But what entity is the zoo?
The zoo's a nonprofit entity that is instantiated by the city, and the city pays them money.
Who owns the animals?
The the city of San Francisco owns the property and owns all of the animals. They've outsourced the management to the San Francisco Zoological Society. And the Zoological Society is a nonprofit organization that signed a lease agreement in 1992, I believe, 1996, 1992. And yeah.
So,
okay. Go ahead.
Sorry to interrupt.
This is a weird question, but you just revealed an interesting thing. So the animals are owned by the city.
The animals, all of the animals at San Francisco are owned by the city, unless the animals are on loan from another facility.
So many of your questions relate to the animals themselves. And if the animals are the purview of the city and not this nonprofit, what entity, who at the city is responsible for the animals? Because the nonprofit is said that they're just managers. So is there a custodian of records of the animals itself that we could pass all this request to?
I've attempted that through, because it's the Parks and Rec that is the city entity that kind of co-manages the zoo, and I've made the same exact requests to the Parks and Rec, hoping that would be the case. That hey, they can request these documents, and they continue to say that I have to work with the zoo to get any documents. That the Parks and Rec do not have that information. And
let me cut to the chase here, because those details aren't as important as the relationship. If the San Francisco, I don't know what's the name of San Francisco Zoological Society, as a nonprofit, has a lease, according to this letter, that they have a lease and management agreement with the City and County of San Francisco, then the question is then two things. One is it a 12L issue? Or is it under specific contracts under the ordinance?
Except the thing to me is that if the animals themselves are owned by the city, then questions about like actual budget, how much did the zoo spend on popcorn for visitors, is probably excluded because of the 12L agreement. But the actual ownership of the animals is owned by the city, so there needs to be a direct link over public records related to assets owned by the city. The assets aren't owned by the zoo, the nonprofit. Like, I don't know whether.
That may be right, so you can see what the city owns. The question is if you want to ask questions about, let's say, what kind of food are you feeding these animals? Or are you providing them with filtered water? Those things might not be available to the city and are within the confines of the contractor and protected in their lease and management agreement. And so then if you were talking about a 12L issue, then that might be beyond the scope of what 12L might allow. But the contract itself, you'd have to look at the contract itself to see what the contract requires as disclosable at that point.
Through the chair, it looked like Mr. Barker.
Hold on, no, let me run the meeting here. Member Yankee?
So we actually we reviewed the contract in the prior case, so I was able to find it, and this is what it says. It says the San Francisco Zoological Society shall provide public access to information concerning the operations of the zoo to the same extent that such information would have been available to the public pursuant to local ordinances if the department had continued to operate the zoo. So it's more than a 12L. They agreed when they entered into this that they're basically fully bound by the Sunshine Ordinance from start to finish.
Okay.
So that's why we ruled in our prior case that they needed to turn this all over.
Got it.
So obviously that contract, which neither side disputed in our prior case, would be relevant to this as well.
Okay, so okay, got it. Okay. Vice Chair Wolf.
Well, at one point, it seemed like something you were saying had prompted.
Mr. Barker, do you want to respond to something I said?
Sure, you read that description. It further says that all information concerning the status of all animals exhibited or otherwise housed or cared for shall be deemed public information subject to public inspection under the Public Records Act. So it makes it really clear.
That sounds pretty clear to me. Yeah. Okay. All right. Do we need any more information? Yes, Vice Chair Wolf.
There is still the interesting thing that I'm not sure whether we can compel someone to show up for a 12L, but because this extends, like the records are definitely public records based on that clause. The zoo not showing up to the meeting is a little bit more hard to parse out. I don't know whether anyone has any thoughts on that.
I think the worst part is they did show up the first time.
Yeah.
And then there's an order of determination, and they took their ball and left the field. I don't, they have to give this, I don't.
Well, okay, so let's finish the discovery part here and get through rebuttals, and then let's talk about how we want to formulate a motion, because I have some thoughts about what to do, okay? So let's finish with the discovery. Do we have enough information? Do we need any more clarification or information? No? Okay, so let's move to rebuttals. We'll note that the respondent is not present, thus waives or forfeits rebuttal. Mr. Barker, if you wish, you have 3 minutes for rebuttal based upon everything and anything we've discussed here today. Let the record know that Mr. Barker, the petitioner, waives his rebuttal time. So now we're in deliberations for making a motion. So I just want to state here that if you're looking for a place to notify, since this is a city contractor, and we don't have the contracting party present here, I think it may be worthwhile for the task force to send a communication to the contracting party. Now, I don't know whether that is in fact Rec and Park or whether it's just the city administrator. In their response letter of October 16th, it states that they have a lease and management agreement with the city and county of San Francisco. Doesn't state any particular department. So unless somebody has read or seen or has any other information as to who the contracting agency or department is, I would leave it. I would suggest that in the motion that you leave it up to the chair to figure that out if you're so inclined.
Yeah, I would just mention, I have a concern that obviously there's a contract out there, and it sounds like the zoo isn't following through on what they agreed to in the contract. So I'm not sure if there's a city contract compliance office or something along those lines.
Oh, yeah.
So perhaps that's where we send it to, send a communication to contract compliance, including, a copy of this contract and say that, we found that they're not in compliance with, I think it's 16.2 actually talks about public access to records and information. So that would be.
What page is that on?
It's I'm not sure if it's in this one. I went back to the August meeting and was able to find it.
Oh, okay. So the whole contract is in there?
Not the whole contract, but the relevant portions are.
Okay. All right. Okay. Compliance. Okay, so is there a motion? No motion? Vice Chair Wolf.
I still think that continuing this at this point in time and bringing it up adjacent to the other case with the same parties and the same issues so that they can both be dispensed to whatever remedy it is at the same time makes sense.
Are you asking to combine the cases?
I'm not sure whether the time, I don't think that they can be combined tonight because the other one isn't on the agenda. I'm asking to continue this one, put them both on a future agenda item when we're theoretically debating putting it to ethics, and at that point in time, combine the two cases, yes.
Well, but the first case, we already adjudicated it. We already found a violation. Are you unable to, are we unable to come to a conclusion on this particular case?
I mean, I think we could certainly find a violation, but it seems like in essence as our next move is to reach out to the agency that has signed the contract. I mean, we can find a violation and then bridge them together.
But to what end? I mean, if you don't take action on this particular case today, what do we hope to achieve a month or 2 months or 3 months from now?
Because ideally I would find a violation and send it to ethics at the same in the same motion. However, I think we want to send both of them to ethics under the same.
So on that note, I'll make a motion to find violation, section 16721 and 6727.
I'll second that.
That gets that to the same as the next stage.
That's another way to do it, sure. I'll second that.
Okay.
6721 and 6727?
Yes.
Right. So moved by Member Highland, second by Vice Chair Wolf. Any discussion? public comment for non-parties.
Yes.
Go ahead, on the phone.
Yes, this is anonymous again. This is not legal advice to the complainant. It is solely directed at the task force. I wholeheartedly support this motion. A private nonprofit that is essentially doing things for the government and has voluntarily come under the jurisdiction of the task force has no right to just not show up and not produce public records. They should be found in violation. Thank you.
Any other public comment? Okay. Seeing no public comment, are we ready for a vote? So I guess the only thing I would, before we go to a vote, is how do we want to, if based upon Vice Chair Wolf's suggestion of having both these items come up, this item and 190448, the previous item on the same meeting, do you want to refer this to compliance and amendments, to try again, or because if you can get them into the room, kind of thing? Member Yankee and Member Vice Chair.
I would, since it already went to compliance and amendments and they didn't show, my recommendation would be we agendize this sometime in the future, along with the other case, for compliance, and just have the full task force do it. This way, if presumably they continue down the same path and don't respond to this as well, then we can take action and at that point refer both simultaneously to the ethics.
Right, so you're saying you have a vote of no confidence that they will not show?
That is what I would, yes. I don't think we want to delay it any longer for Mr. Barker to go to compliance and amendments, have them not show again, and then come back here again.
But how can you presume they won't show now that they have a second violation against them?
They may.
But if they do, and you can get an audience with them, maybe there would be a different outcome.
Well, that's why I would recommend that just come back to the full task force.
Okay.
I mean,
Okay,
they would have an audience here as well.
I'm just opening the field up here.
I
Member LaHood.
agree, because I think at this point, if getting a second violation makes them take it seriously, great. So I
Okay.
think that would be a positive outcome.
To do what? To do what I suggested, or to do what Member Yankee's suggesting?
Find the second violation and say, if we find the second violation, bringing them both together for compliance review at a full task force hearing.
Got it. Vice Chair Wolf.
I mean, I'm just a broken record at this point. So, I think that if they haven't showed up to 3 meetings, they've established a practice or a communication of what they feel is. They very explicitly said they don't feel that they're covered by the Sunshine Ordinance, despite what we've heard today. So I don't think anything's going to happen until they're generated, until they're put into a new venue. I don't think they're going to engage us, honestly.
Okay. I'm going to make a suggestion that it is highly unusual to have a contractor come, because based upon what Member Yankee had iterated or stated, based from the contract itself, it doesn't necessarily require them to appear. This is the city's contract. This isn't, the flow, the process flow has to start with our confines here. With the city is here. Really the city is the respondent as the contracting agency. So if the city is not aware that this is happening, then I think we should request an audience of either the city administrator or contracts compliance department or something like that to be at the meeting, or at least to respond, as to, thanks for bringing this to our attention, kind of thing.
I have a question. Would it make sense to vote on the current motion, or should we amend the motion so that if this passes, then we would like to bring it to the full task force with the contracts department responding as the city, representing the city in response?
That is my
Okay, that's my
inference.
amendment.
Okay, does the maker accept that amendment? Who is the maker? You are the maker.
Yes, yes.
The second? Who seconded it? Member Martin?
I'll second it. I don't know if.
I don't think I was the maker, though.
I think Martin was the maker.
I think-
or I was the maker.
I think it was
Oh,
Brian.
Wow.
Okay.
And Member Wolf was the second.
I was
Oh,
the
that's
second.
right.
It's
Okay.
fine. It sounds good to me.
It sounds good to me, though.
Yeah.
Sounds good
Okay,
to me
so
too.
let's be clear about what the motion is.
Okay, so the motion is to find a violation of 67.
21.
21 is 6727, and to schedule this item and item 19048, which is set to return back to the task force for review based on recommendations from the and report from the Compliance and Amendments Committee, and to request the presence of either the city administrator or somebody in a department overseeing contracts compliance, or the actual contracting agency or department to appear to respond to the contract and the provisions in the contract relating to the Sunshine Ordinance. That sound right?
Good to me.
Okay. Got that, Cheryl? Okay, great.
Okay,
Oh.
vote.
Okay, well, no, we need public comment. Public comment on the motion. Seeing no public comment, are we ready for a vote?
He already commented on the motion.
Oh. Oh, okay. Then let's vote.
Member Highland?
Aye.
Member Highland, aye. Member Wolf? Or
Aye.
Vice Chair Wolf, sorry. Member Yankee?
Aye.
Member Yankee, aye. Member Martin?
Aye.
Member Martin, aye. Member Tesfaye, absent. Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey, absent. Chair Wolf?
Aye.
Chair Wolf, aye. 1, 2, 3. Motion passes.
Call next item, please.
Item number 10, file number 19093, complaint filed by Michael Petrellis against Sean Ellsburn and the Office of the Mayor for allegedly violating Administrative Code, Section 6721, by failing to respond to a request for public records in a timely and/or complete manner.
All right, complaint committee.
Calendar related. And it has to do with the Prop G calendar and other calendars.
In the microphone, please.
Sorry. And the calendar applying to a chief of staff, not just the mayor. We referred it here, document, so. Anyway,
Okay,
calendar case.
calendar case. Okay, great. 5 minutes, Mr. Petrellis.
Hi, Michael Petrellis again. I've been down this road before with the mayor's office about calendars. There's no dispute that the chief of staff keeps a calendar. The matter again is obtaining it, and I mean the full calendar, not just one entry on a single day where Sean Ellsburn listed he had a half-hour meeting with the mayor, and nothing's listed about who was there, what the discussion was. I do believe that the mayor is a foe of Sunshine. Had to deal with her since she was on the fire commission and would not turn over documents. She was the same way as a supervisor, the same way as the president of the board of supervisors, and she's carrying on her opposition to open government as mayor. I have to get in touch with Cheryl by the end of this week to find out exactly how many complaints have been filed against London Breed in any capacity as a public servant, and find out what the determination was here at the Sunshine Task Force, whether she was found in violation or compliance. Regarding this matter, I have not heard from the mayor's office regarding my original request for the full calendar of Sean Ellsburn, her chief of staff. If those records had been provided to me, I would have shared them with you before today's meeting. I'm glad you're hearing this matter tonight. Thank you.
Are there any persons or witnesses to provide any facts or evidence on behalf of the petitioner, the complainant? Seeing none, respondent. Mayor's office, Mr. Heckel.
Good evening, Chair, members of the task force. Hank Heckel, the compliance officer in the Office of the Mayor, here to respond to Mr. Petralis' complaint. This case really gets down to one basic issue. It's an issue of document production in response to a request under the Sunshine Ordinance versus any requirements around creating documents or maintaining documents. And we can't produce documents that don't exist. So just to give you the background, on August 16th, Mr. Petralis sent an immediate disclosure request to our office seeking Mayor Breed's Chief of Staff, Sean Ellsburn's calendar from October 1, 2018 through close of business that day. We timely informed Mr. Petralis that we were invoking an extension of time to respond in order to consult with other departments. Within the extension period, we timely responded and provided Mr. Petralis all of the available calendar entries for Chief of Staff Ellsburn for the period of time requested. Those are in the packet. They comprise over 40 pages and span from February 2019 to August 16th, 2019. This very issue of whether the Chief of Staff is under some affirmative requirement to create certain calendar entries and retain them for specified periods of time has already been adjudicated a few years ago and was finally resolved by the Ethics Commission on an essentially identical complaint that Mr. Petralis made against the predecessor to Chief of Staff Ellsburn. It was made to, with respect to Mayor Lee's Chief of Staff, Steve Cava. And the Ethics Commission found no requirement. They did not find any requirement in the law that the Chief of Staff was required to maintain a calendar, a certain kind of calendar for any length of time, and voted to find no willful violation of the Sunshine Ordinance. So this case is based on a fundamental misconstruction of the law. And just to clarify the facts here, Mr. Ellsburn does use an Outlook calendar. He uses it for his own reference and convenience to schedule meetings and retains them typically for about 2 weeks, and then for purposes of convenience and efficiency, will no longer retain entries of past meetings that are no longer relevant. So the documents we produced to Mr. Petralis were the documents that were still, there were some entries that were still retained by Mr. Ellsburn. So this complaint's based on a fundamental misconstruction of the law here. The Sunshine Ordinance is directed to providing existing records transparently to the public. It does not deal generally with records creation and records retention. Rather, state and local records laws govern records retention. Specifically, Local Admin Code Section 8. I defer the task force to Admin Code Sections 8.1 through 8.3. They're the governing law here, and I would also submit that even violations of those provisions, which we hold there is no violation, would not even be within the jurisdiction of the task force, respectfully. The jurisdiction of the task force is limited to violations of the Sunshine Ordinance, the PRA, and the Brown Act. The only real place where the Sunshine Ordinance deals with the issue of document creation is in the Prop G calendar requirement, which we're all familiar with, which requires certain specified officials in the text of that law, certain elected officials and department heads, and members of the Board of Supervisors to maintain a calendar for historic preservation so their meetings can be recorded and made available to the public upon request. The text of that section of the Sunshine Ordinance is very clear. It does not mention senior staff members, even a chief of staff. There's just simply no reference to that. And in fact, that provision was amended once already and was amended to add the Board of Supervisors members, but it did not add chiefs of staff or deputy chiefs or other senior staff members. So they're just not subject to that requirement, so there can be no basis of any violation on that score. So it's just not clear what authority, if any, Mr. Petrellis is citing to establish some violation of an operable provision that the task force has jurisdiction over. There is a provision that relates to preserving documents in the Sunshine Task Force 67.29-7. That does not apply in this case. It's not a document retention provision generally. It's referring to the documents that are created in the course of business. They should be maintained in a business-like manner so that staff can respond to requests and find existing documents and provide them when they're requested. But of course, in this case, these documents don't exist because there was no requirement to affirmatively create or retain them. And I would refer the task force to the record, which includes letters from the city attorney's office making these arguments to the Ethics Commission. And the pages 1278 to 1283 show the record of the Ethics Commission's decision on this, pretty much this exact issue. And the letter to the Ethics Commission from the city attorney is page 1278 through 1281, through 1283, and that pretty much sets forth the operative arguments here. And I'll be happy to take any questions that the task force has.
Thank you. Any persons or witnesses provide any facts or evidence against the, in support of the respondent? Seeing none, members? It's Mr. Heckle. I have a couple questions. Sorry. One is, and this is a question that's that came up actually in the previous case that you were had mentioned. What is the job classification of the chief of staff for the mayor in general?
You mean under the, like in terms of employment, like the labor code? I don't know.
It's, they have mayor staff 1 through, it looks like 17.
Mm-hmm.
Do you know which one he might be?
I don't know which one. I just know that he's a member of the mayor's staff. I mean, he's the chief of staff.
Yeah, but he gets paid by the city. He's got to have some sort of job classification.
That's true. I don't have that information right now.
Okay, because that would determine whether they are a department head or not.
Well, I mean, sorry, go ahead.
And the application for the calendar retention is for the mayor, board of supervisors, and department heads. So that's the question. The mayor is not the department head. Mayor is the mayor.
What are you basing that on, Chair? I mean, the chief of staff is not the department head of the office of the mayor. The mayor is the head of the office of the mayor. It's her office.
Well, but we have department heads for all other parts of the executive branch.
Right, because those are subsidiary parts of the executive branch.
They're
not part of the. They're not part of the office of the mayor. They're different departments.
Well, I don't know. I don't know how the mayor's office is organized. It may be organized in departments, and he may be the department head of those departments within that office. I don't know. It really depends upon the job description, and that's why I'm asking, because there is a classification for the mayor. There's a job classification for the member of the board of supervisors. Mm-hmm. We all have as volunteer appointive members here. We all have job classifications. I just like to know which one is for the chief of staff.
I don't have that information, but okay. I will say that I don't view his employment classification in sort of the labor code, which sort of really relates to issues of compensation and the terms of your contract and whether you can be.
Is that a determination that you can make?
I mean, there's no contrary authority. The Prop G doesn't say anything about someone's labor classification. It just identifies
But the
certain
ordinance-
individuals.
But the ordinance does.
The ordinance doesn't mention
It does.
labor classifications either.
Yes, it does. It says the mayor, the city, and every department head. Those are job classifications.
Right, but the department head is, whether someone or not is a department head, I don't believe is determined entirely or maybe even partly by their labor classification. I mean, I don't think there's anything in the legislative history of that section of the Sunshine Ordinance
Well,
that says that.
No, there is job classification 0961, 2, 3, 4, and 5 that are specifically department head in the civil service listing from the actually in the Department of Human Resources classification and compensation database.
Mm-hmm.
So that's why I'm asking, because there are these classifications that are specific to department heads. And if the chief of staff, there's no listing for chief of staff. So obviously there's something called like the chief of department, which is for the fire department. So you have the fire chief, and then you have the deputy chief of the department, which is the deputy chief for the fire department. But there's no other such animal called chief of staff. So that's why I'm asking what job classification is he? Because if he's listed under a department head, if that's his job classification, then this does apply.
Yeah, I mean, it's an interesting question. I don't believe that. I don't know. I can't represent to you one way or the other exactly what his job classification is. I believe it's something more along the lines of executive. I don't believe he's considered the department head, and I don't think even if, I mean, no one's made the argument that he's the department head of the mayor's office.
Well,
I think that would be a strange argument. I mean, people associate the mayor as the head of the mayor, the office of the mayor. It's named after her.
But Mr. Heckel, that's what we're here to ascertain. This is discovery. We're trying to discover what the facts are. So
right. I thought we were. Is this not? Sorry. Go ahead.
All right. Transparent California. I don't know if you're familiar with it. Does a annual PRA. He's listed in there as mayoral staff 17. So if you want to look at the job classification, as of 2018, he was mayoral staff 17.
Mayoral staff 17, okay. Thank you. Yeah, Mr. Heckel, you were going to say something else?
Oh, I mean, I was just going to address the issue of whether, I understand you're trying to ascertain the facts and the applicable standards here, so I appreciate that. I don't, the argument hasn't been made in this case before that Sean Ellsburn is the department head for the office of the mayor. I've never heard that argument before.
This either could help you or it could not help you. If he's not a department head, then the question's answered. There's not much else to worry about at that point. But I think in the public's interest, I think it's a pertinent question. You have a job title of chief of staff. It doesn't exist anywhere in the city's database, and we have a question as to what this is the top employee underneath the mayor. There's no deputy mayor, so there's no this is the person that runs the office. So the question is does that person, is that person the de facto department head or not? Now, the fact that there are job classifications called department heads, okay, there you have that. If in fact Mr. Ellsburn is under 0905 mayoral staff 17, then that's a different question. But the question then is, even in this in this particular classification, is that position also considered a department head, or is it something else? And that's what I'm asking. Let's get clear. What I'm asking is just we get clear on that. So I brought up the job description for this. talks a lot about being a liaison, providing opinions and concerns, touches upon emergency preparedness, public safety, public and private transportation. Positions may manage and analyze information utilized, develop for budgets, grants, contracts, so on and so on. Other pertinent areas of function and requiring direction from the office of the mayor. Incumbents report to the mayor or other supervisory staff in the mayor's office. Positions in these classes are unique to the office of the mayor and function to administer, so on and so on. So to me, it doesn't sound like he's a department head, or that position is department head, just based upon the description that incumbents report to the mayor or to other supervisory staff. Okay, it's based on reporting. According to Civil Commission Rule 109, the duties specified below are representative in the range of duties assigned to this class series and are not intended to be an inclusive list. Promote and promulgate mayor's policies? No. Serve as liaison? No. Manage segments of the office of the mayor, responsible for programs, operational activities, or projects. Supervise, train, and evaluate staff and monitor the work, production of staff, consultants, contractors performing for the office of the mayor. Manage budget and fiscal analysis. Manage direct resources. Manage schedules and coordinate meetings and appointments for the mayor. Manage and coordinate with the mayor for a mobile advancing team. Direct and instruct city departments regarding policy and decisions that impact their operations. Nope, not necessarily management position. Yeah, I'm not convinced.
What job description are you actually looking at, Bruce? I mean,
I'm sorry?
I'm trying to figure out what you,
I'm looking at job description, the job, based upon what Member Yankee had read, that his job description falls under mayoral staff 17. And under the highest department head, the job description definition under broad policy direction creates the mission and long-term vision of a city's department or agency. For the mayoral staff, 17, under direction, serves as manager of the office of the mayor, performing duties. I think they're completely independent at this point. Okay, so that answers that question. He's not a department head.
Okay.
At least for this particular case, I would, it's pretty, to me, it seems conclusive. I'm not saying that it is, but it appears that way until somebody says otherwise. Okay, moving on. Any other questions?
Just-
Member Martin?
Yeah,
Hold on. Go ahead.
Just point of information, I was also searching the database. There are 5 levels of department head, and those are numbers 961 through 965, and they're
Right.
distinct from the one you were reading.
Exactly, yeah. Go ahead, Member Martin.
Sure, Mr. Eggle, you're pretty much saying, listen, there's an ethics decision that came out on pretty much on point on this issue, and that should be the end of it. Is that correct?
I don't think that's all I'm saying, but I think that I definitely do. I'm arguing that the task force should sort of land in the same place that the Ethics Commission did on pretty much the identical issue.
Okay, but if let's say the chief of staff did keep a calendar, and he had it, and he kept public meetings in it, and it wasn't a private calendar, would you agree that that would be something that's subject to the release under the Sunshine Ordinance?
Absolutely, I would, yeah. I mean, I don't think that's what we're disputing. We didn't withhold anything. We gave Mr. Petralis what we had at the time because that's what was created and retained, prior to his request. Of course, if a request comes in, then you have a retention obligation, certainly regarding those documents that are subject to the request. But what we're saying is generally the obligation to create these types of records and length of time you keep them is not even governed by the Sunshine Ordinance. It's governed by record retention laws, which is in the different section of the government code,
Right.
not the PRA, and it's in the admin code,
Right.
section
So those
8.
people are obligated to keep a calendar. The others essentially keep a calendar at their own peril.
Yeah, I mean, they keep
Correct.
they keep a calendar for their own use, sure. I mean, they keep a calendar when they need it. I mean, he could not keep a calendar at all, I would argue, if he doesn't feel the need for it. But also, even when he does create certain entries, there's no general document retention requirement around those.
But if there was one, it's something that would be subject to Sunshine.
If there was what?
A calendar that he kept.
Yes, and we produced that. We produced the calendar he made and kept, and that existed at the time of the request. There's no dispute about that, and I haven't heard Mr. Petralis dispute that. I mean, if he is, I can point you to the section in the packet where those materials exist and represent to you that's what we had, and we didn't have anything more than that.
Okay, thank you. Mr. Petralis, can you come forward?
Hi.
Hi, thanks. How do you respond to the Ethics Committee decision about the Chief of Staff's calendar not having to keep one? And
I think they were wrong in what they decided at the Ethics Commission. I believe that the Chief of Staff is creating a detailed calendar listing who he's meeting with, when he's meeting with people, and where. And that that you can't have Chief of Staff to the mayor of San Francisco not creating such a calendar with all that information. What if the mayor needs to know last month whether Sean Ellsburn met with people on December 1st and they discussed housing issues? She'd be at a loss. She wouldn't be able to look back and say, well, yes, he did meet with homeless people and housing advocates on December 2nd at 1 p.m. in his office at City Hall. I just cannot accept that here in San Francisco, the Chief of Staff is not keeping a public record that shows who, when, and why he's meeting with people. And I think that the mayor is again showing how she is against transparency in her office.
so, and just correct me if you will. So you think there is a calendar out there that hasn't been produced? Is that what it comes
Yes,
down to?
I
Okay.
do believe Sean Ellsburn, in his capacity as the Chief of Staff, is keeping a detailed daily calendar, and he's not producing it.
Okay, thank you.
Okay, so are there any other questions for Discovery? Do you have all the information?
Wait, one more.
Go ahead.
They did produce something to you. I'm looking at these pages here. Was that just the 2-week retro period that they say is kept before it self-destructs or gets deleted or whatever it is?
I'm sorry, rephrase that?
Yeah, sorry. They provided some entries here, correct, to you?
Right, like on many days, there's just one entry, which I believe is where he's meeting with the mayor. That's it. That's the only entry. My question is, why is there only one entry? Is that all he did officially for the mayor on that day? Is he just sitting around the rest of the time looking at YouTube videos of, cats and dogs? What is he doing?
Thank you.
Okay, anything else, folks? Should we move to rebuttals? Yeah, Vice Chair Wolf.
Now, Mr. Petralis, you've captured a bunch of these calendars over time. Did you have a chance to review Ellsburn's calendars back when he was a supervisor in maintaining a calendar?
I have not looked at those, no.
Okay. I was just curious whether there's a difference between the calendar that was maintained then and different, just as a curiosity about maintenance of calendars, but it sounds like those records aren't accessible to compare.
Right, and I have followed your discussion about whether he's a department manager, whether Prop G applies, et cetera. Okay, yeah, I understand that. Regardless, though, there is the matter of he is creating a public document, a daily calendar with details in it, and he's not producing it. That's where I'm standing.
I have a question for Mr. Heckel. Seeing as the chief of staff has this pattern of or practice of deleting the calendars after 2 weeks, is he maintaining a record of his activities in a document that is called something other than a calendar?
No, I mean, there's no other like version of a calendar that you'd think of. Like, there's no other like schedule, or there's not some other document. I'm not trying to be cute and say there's some other document we call something else. You know,
But maybe is he maintaining a record of activities, record of something that might otherwise be a running document by date that would reflect things that he has done in the calendar and meetings that he's had.
I don't believe so in any definitive way. I mean, I can't speak to that. I could certainly, I don't know for sure. I don't believe that to be the case. So anyway, I mean, he has other documents. He uses email, for example. So, I mean.
Well, I know in some offices there's like an office calendar too, where everyone's activities are on one calendar. I think the bar still makes our office keep two calendars, one paper calendar and one electronic calendar. But anyway, that's just.
Yeah, we don't keep an office calendar. I can tell you that.
So, Mr. Heckel, what's the current retention policy for the mayor's office?
So
documents or records.
I actually have the retention policy. I brought copies of them. If you want to take them into the record.
Matter of public record.
Okay.
It's my question.
Right.
So.
Thank you. I have enough for. Oh yeah, it's the same thing. So if you, thank you. So the clerk's providing you with the policy, but I mean, I think I can say generally it categorizes documents into certain basic categories. There's there's a sort of a general statement that the mayor's office retains records for their period of their immediate or current use unless longer retention is necessary to comply with.
Does it include calendars?
Well, that's a good question. So among the categories, there are things that are sort of permanently retained. There are current documents, and then there's a class of non-records, such as phone slips and day-to-day memoranda. Page 2 of the document refers to, at the top, where no retention period is specified by law, and it refers to
the only
a schedule. So there is a schedule, and getting to directly to your question, in the schedule there's a reference to the Prop G calendar, which is retained for 2 years under the schedule, but no other staff's calendars, and that's on the second to last page, the bottom of that schedule in the policy.
So let me ask you something. So documents. Let's talk a little more generally about documents that staff work with. Would you say that this is the full compendium of all the documents that are in custody and managed, covered under the Sunshine Ordinance in the mayor's office?
I think the policy covers the totality of records that may exist. Yeah.
Okay, so it does not state a staff calendar.
That's correct.
Now, staff calendar is generally kept on city-owned devices or paper that were calendars that were, that are purchased by the city, they belong to the city, public documents. Can we agree on that?
Yeah, and I think generally people tend to use Outlook calendar on their work computer and then refer to it on their devices.
So no matter where let's talk about calendars for a second. No matter where a calendar is kept or recorded, whether it's hard copy, whether it's on on Outlook or what have you, or in somebody's smartphone or what have you like that. If let's say we didn't have technology and electronics and it was still all on paper, would that calendar then be considered a public record?
Yeah, I mean, generally, I think yes. We're not saying that calendars are not public records.
So it would then go to say that it's then disclosable.
Right.
Okay. So now let's get back to the issue here. This particular staff, or any staff, they all have calendars, okay? There's no retention policy for that particular item. So without that, it should be kept indefinitely.
I mean,
if there's no specificity, I mean, it falls under the retention policies of either the CPRA or the Sunshine Ordinance at that point. It defaults to that.
So I think the policy is an affirmative document that tells you what you have to retain. So to the extent it doesn't tell you to retain something, you don't have to retain it.
No,
So that's the purpose of the policy.
The policy is to say how long all public documents are to be retained for.
It's not just that, respectfully. It talks about documents that have no retention. It talks about it in Category 4, no retention required on page 2.
If I may.
Go ahead, Member Yankee.
Under that bullet point that you just pointed out, that's what I'm reading, where it says, where no retention period specified by law. It says, further down in that paragraph goes, records shall be maintained for a minimum of 2 years. So why is he deleting them in 2 weeks?
What are you referring to? I'm sorry.
So, page 2, second bullet point, it says, where no retention period specified by law. It says, when no specific retention period is specified by law, the retention period for records that the department is required to retain shall be specified in the attached record retention destruction schedule. Records shall be maintained for a minimum of 2 years.
That's referring to the documents in the schedule. It's saying to the extent a document is scheduled, the schedule sets forth retention periods. If it doesn't set forth one,
right, so
then the minimum is 2 years. But this document does not fall into the schedule. It falls into Category 4, no retention required. Because
it's under Category 2, which says current records. Current records are records that for convenience, ready reference, or other reasons are retained in the office space and equipment of the department. That seems to me like a calendar.
It's not retained for the convenience of the office.
Well,
I mean, if we retained it for our convenience, we'd retain it.
Well, let's go back to the ordinance then. Under 67.29, the index to records, every department and public officials must maintain it. The index not be, so this section says, the index need not be in such detail as to identify files or records concerning a specific person, transaction, or other event, but shall clearly indicate where and how records of that type are kept. Any such master index shall be reviewed by appropriate staff for accuracy, so on and so on. If what's on the back page is your index of records, then it's not that particular record is not stated.
It's not the index of records for the office.
Okay.
The index of records is on the website. There's a city website.
Right.
I can't quote it to you chapter and verse, but it has the indices of records for all city departments. That's where the mayor's office index of records resides.
Right.
I think, and I know this is a retention policy from, I think, 2014, but I think it's the second page of the packet, under B, There's records and other documents that are not expressly addressed by the attached schedule. There's no chief of staff calendar in that schedule. May be destroyed at any time provided that they have been retained for periods prescribed for records for substantially similar records. Well, I would think that, a Prop G calendar is a similar type of record. It's a calendar. But I mean, this is the first time I'm reading. I don't know.
Sorry, what specific bullet were you referring to?
I mean,
Or just
the
what
chief of staff
site in the
Yeah, sorry, page
policy?
2 of the packet.
Yep. You mean of the policy or of the packet?
The
Sorry.
policy, sorry.
Yep.
B says records not addressed, and chief of staff calendar is not addressed, correct? It's not in there. Maybe not even contemplated, but it says.
That's right.
Yeah, it says, records and other documents or materials that are not expressly addressed, it's not, may be destroyed at any time provided that they have been retained for periods prescribed for records for substantially similar records. Well, the only calendar reference I can find in that outline is the Prop G calendar, and it says 2 years. I mean, I don't know if that's an area of exposure for you, or I don't know.
May I respond to that?
Yeah, please.
So I would say the Prop G calendar is fundamentally different from any other calendar. I mean, it's one of the, I think it's the only instance in the Sunshine Ordinance that has an affirmative document creation requirement. It has very specific requirements. It was added by, through a ballot measure. It lists the officials that it applies to. It lists in very detailed ways the types of information that have to be included. We do all of that for the mayor. We keep a Prop G calendar compliant with that section of the law. I think if you, to sort of go into a place of, well, all calendars are kind of like a Prop G calendar, is to essentially just sort of read Prop G out of the law and just say, okay, everybody has this calendar requirement.
Yeah, I don't think I'm saying that. I'm just saying with the retention policy that looks to be outlined, the way it could read is that if there are calendars within the office and there's no retention policy talking about calendars and you're looking to a schedule, a layperson's going to go, well, let me see, how long do they have to keep the Prop G calendar? Well, my calendar might have to be kept for 2 years. I mean, I can see how that could be deduced from a retention policy. If you have a written record in a public official's office and it's your calendar, how someone might say, I might need to keep this, if you're being overly cautious.
Well, I mean, I think in our office, you'd probably consult with the city attorney.
Probably.
And they would advise you that this applies to the Prop G calendar, and it says Prop G calendar for that reason. It doesn't apply to other calendars.
And just to follow up on that point, Category 4, you actually have a list of some of the things that no retention required, and you go down to the nitty-gritty of telephone slips, telephone message slips. I mean, if you're but again, a calendar, which presumably was a paper calendar back in the day this was written, is not mentioned, which suggests again that does not fall in this category. So once again, the calendar is in limbo, from my reading of Section 4. I think that's instructive to look at that section, Member Highland. I would argue that the full list of examples there embrace this type of sort of calendar that's kept for the sort of personal reference of an official. Telephone message slips, notes from ongoing projects, preliminary drafts that have been superseded by subsequent versions, routine emails that do not contain information required to be retained under this policy, miscellaneous correspondence not requiring follow-up, or departmental action notepads and chronological files, which But
could include a calendar.
On the same note, you can say that are not required for the function or continuity of the department. Well, a calendar is required for the continuity and functioning of the department. Again, you can read it two different ways. And again, it's not listed, it's not mentioned. And to Member Rodman's point, I don't see it in Section B either. So it's glaring by omission. So where are we?
So I have a couple of things just following along that line. You have a section which says no retention period specified by law. Okay, so those are for all items where no retention period is specified for those records. Okay, in the Category 4 section, that part that you were just discussing, it's the first two words that are important. Specific examples include. It's those examples, not here are some examples that are, maybe included or not limited to. There's none of that language. These are specific examples, and calendars are not part of that listing. So I'm not flowing with that particular part. The previous sentence, where it's more general, where it says examples include documents and materials generated for the use and convenience of the person generating them, draft documents which have been superseded or subsequent versions, and duplicate copies of records that are no longer needed. So to me, that would be, if we were going to be talking about something in a more general sense, it would be that. And I don't think just for the use and convenience of the person generating them, I think calendar's a little bit more than that, because it speaks to what a person's doing from day to day, that a manager might want to refer to. The other point is, getting back to 6729, the index to records, I think it goes a little bit more pertinent to what we're dealing with here. Halfway down, it says, each department, agency, commission, and public official shall cooperate with the city administrator to identify types of records it maintains, including those documents created by the entity and those documents received in the ordinary course of business, and types of requests that are regularly received. Each department, agency, commission, and public official is encouraged to solicit and encourage public participation, developing a meaningful records index. The index shall clearly and meaningfully, it goes on and on with regards to that. The index shall be sufficient to aid in public in making an inquiry or a request to inspect. Any changes in the department, agency, commission, or public officials' practices or procedures affecting accuracy of the information provided to the city administrator shall be recorded by the city administrator on a periodic basis, and it should be maintained on the city's World Wide Web. So I go to the index.sfgov.org and I look up the mayor, and it says no published schedule for this department. It is blank.
I believe there's an index for, it might be listed by sort of like sub-departments, by like economic and workforce development, mayor's office of housing and community development.
Says mayor community development, mayor's office on disability, mayor budget and legislative, mayor criminal justice, mayor economic development, mayor housing, and that's it.
Right, and so there are indices for those.
Right,
I believe for those.
But for this particular case, we're talking about a member of the mayor's staff that is not in any of those departments. They are part of the what is been created and required by the city administrator is mayor's office. And so it's up to the city administrator to create this and maintain it. So it just says mayor's office. It gives a department contact, Shalonda Baldwin, with her phone number and email address, ratified on blank, and underneath that says no published schedule for this department. So for all those other departments, there's an index of records, but there's no index of records for the mayor's office that serves for the function of the mayor itself.
Yeah, I don't know one way or the other. I don't have that page in front of me. I mean, if I'll take your word for it, of course.
It's
but
there.
I mean, I don't think this case is about the index of records, so I just don't.
Well, it's about records. It's about records.
Well, everything here is about records.
Right. So this is about a record that is neither referenced in the retention schedule. It's about records that are specified in general about retention in the retention schedule, and not just the retention schedule list of records that is here, but there's possibly other records beyond this that didn't require to have a limit on retention that should be listed in the index of records.
I mean, they're
for that
two different
department.
things, respectfully.
It's the same thing.
The index of records is a different animal. It does not govern the retention policies. It's governed by our retention policy. That's what we're looking at.
Mr. Heckel,
And also, sorry, go ahead, Chair.
Mr. Heckel, you do not get this type of record or this category without having an index of records first. That's where it begins. It begins at the index of records. How do you then know what records to retain or not?
Well, it exists, doesn't it?
If they exist, then they have to be in the index of records.
No, I'm saying the policy exists.
If the policy exists and you have a schedule for retention that's based upon records, those records have to be part of an index of records. Where is the index of records?
I mean,
because it states in the policy that if there is no where no retention period is specified, and if it's not listed in here, I imagine in this list it's specified because the law states, or there's some limit, the law states that there is some limitation. Okay, I'm just, every single one of these has a particular period of time on it, except administration correspondences, general correspondences. It says non-available. So that means that's one of those, 2 years, where it doesn't specify a retention period. But if this is not the exhaustive list of records that are kept by the mayor's office, then it must be in the index of records. That's the requirement under the ordinance.
May I respond?
Yeah.
So, as far as I know, this case, Mr. Petralis didn't reference the index of records. This case is not about the index of records. It's about Sean Ellsburn's calendar, which is a record that exists in the mayor's office. Mr. Petralis knows that because he requested it and we produced it to him. So, I mean, if you want to sort of go casting about for whether we just sort of, different provisions in the Sunshine Ordinance and whether we've complied with them, I mean, it's your prerogative, of course, but I don't think that's part of this file. And the operative document is the document retention policy. And the way it works is it's not an exhaustive list. It has categories, and then it has certain types of documents where it may be specific types of documents may be legally ambiguous. So there's a schedule that lists for those documents at the discretion of the office. Okay, these are documents that have certain significance. This is the result of a process with the city attorney. The city attorney vets the document. The city attorney signed the document, and they made recommendations. These types of documents should be retained for these amounts of times. But for things that aren't on the schedule and fall into the sort of non-record category 4 in the retention policy, which is what I'm arguing the Sean Ellsburn's calendar falls into, there's no retention. That's the point we're trying to make.
Well, but the point here is it says under B, for records not addressed in the record retention policy, it doesn't mean that the records don't exist or they're extraneous from public disclosure. It says records and other documents or materials that are not expressly addressed by the attached schedule. Okay, if they're not specifically addressed specifically by that schedule, they must be listed in the index of records. That's the purpose of the index of records. So while you're saying you're talking about Mr. Petralis was asking for a document. You're saying that the document was produced. He doesn't believe that those are all the documents. Okay, it's our job in discovery to determine whether the documents exist or not. Okay, so the concern here is that by providing us with a records document and retention and disposal schedule, we're looking for that document. The document isn't in there. Okay, so this is not applicable to that, okay, except that it's applicable to the point of, well, it doesn't even point to where no retention period is specified by law because it's not listed, okay? And it doesn't apply to no retention required because it's not listed in this schedule. Everything, the policy that applies in here applies to the schedule that's in the back. That's what this policy is for.
I don't agree with that. I think the schedule is a subset. The schedule is a subset of the policy. The schedule doesn't describe all documents subject to the policy.
Tell me where in the policy it talks about records that are not in the schedule. That's in B. Records and other documents or materials that are not expressly addressed in the attached schedule may be destroyed at any time, provided they have been retained for periods prescribed for records for substantially similar records.
Exactly. I mean, that's the answer in part.
Okay.
These records are not described and therefore would fall into that bucket. No retention.
Right. So is there an official? So this is an official position of the mayor's office that all staff calendars fall into this B?
Well, I think that all documents that are not specified to be retained in some part of this policy are not subject to retention. That is the position of the office.
Is that the position of the office?
Yes.
That get staff calendars other than Prop G calendars fall under B?
Well, I'm not going to sign off that they fall under B because I think it's sort of a complex analysis of which section, but the structure of the policy is such that if it's not in a category of retention, whether it's sort of permanent historical or ongoing use, or there's a specific period in the schedule, there's this sort of catch-all of Category 4. And I think B as well. I mean, you could sort of parse out whether it's A4 or it's B, but I think they kind of work together. I mean, the document is perhaps, somewhat difficult to parse through. I think it's a legal document to some extent. I don't want to.
We don't understand.
No, I do understand.
Saying that we don't understand.
No. I think we all understand. Well, I think you understand the provisions as you're reading them.
We have legal counsel here. They provide us with a memorandum of how we should understand the arcane points.
Yeah, no, I'm not saying. I'm saying even for myself. That's why I don't want to get pinned down to say yes, it's B, because I don't know. I'd have to consult with the city attorney to say yes, it's B. I think the totality of the policy definitely leads you to this result, is that it doesn't fit into a retainable category.
Okay.
Through the chair.
Go ahead, Member Mark.
I think B is. The end of B. I just think I don't know if it's a drafting error or what, but prescribed for records for substantially similar records doesn't make much sense. And that provided proviso, I think, is. It'd be nice if you had just written and destroyed at any time. Period. Don't know. If there's not similar records to something in what's outlined, I don't know why that's there.
Yeah, I think it's sort of legal kind of CYA. I think the problem is it's sort of like you could have documents like, what's the retention for a papyrus scroll that someone writes their notes on? I don't know. We could imagine all kinds of, limitless types of documents that aren't going to be specifically laid out in the retention policy.
Getting back to the complaint, Mr. Petralis thinks there's stuff that was on that calendar that's not on that calendar, right? Yes. Okay. And we have no way to prove that. Correct. Okay. So, I don't know what to tell you.
Well, the thing is here is there a level of reasonableness for this particular type of document? It's one thing to say that we provided all the documents that we have custody for. Okay? That's one thing. It's another thing to, and you can somewhat presuppose that if somebody keeps a calendar and they kind of run the office of the mayor, that they kind of have to know when meetings are and what they're, what's going on throughout the, maybe not. Maybe they're able to retain it all in their head. The question is there a document or isn't there a document? Is there a regular practice for this? There is requirements for specifically for the office of the mayor under 6729-1, which regards records to survive the transition of officials. It's not just for, it specifically says the office of the mayor, not just the mayor, but the office of the mayor by any elected city and county official and by the head of any city or county department, that all documents prepared, received, or maintained are the property of the city and county of San Francisco, okay? So if the office of the mayor created or prepared a document of any kind, including a calendar, okay, it's the property of the city and county, which makes it a public document, okay?
May I respond to that?
Sure.
Because I'm glad you cited this provision, because I think this strongly supports our argument, actually. The last sentence of that provision is, the originals of these documents shall be maintained consistent with the records retention policies of the city and county of San Francisco.
Correct. No.
And we've referred to our record retention policy. My argument is that that policy dictates the retention for various documents, including this one. So I think that's probably the most specific example in the it is the most specific example in the Sunshine Ordinance of sort of a record retention requirement. And it's saying, to the extent officials transition, it doesn't mean you can just get rid of stuff. You have to refer back to the retention policies, and we do have a retention policy, and that's what's operable here. It doesn't require retention of Chief Ellsburn's calendar for, beyond his sort of daily use. And if I could also, this sort of hanging out there, essentially Mr. Petralis is kind of calling us liars. So, I'll represent to you, we gave him what we had. There's no other parts of the calendar we're hiding. These were the calendar entries that existed when he made the request. The reason that they're sort of like these single entries on the earlier days is because some of those are like recurring meetings where they recur, every second Tuesday or whatever it is, or not even, they were just ongoing at the time during that span of time. So those are sort of artifacts that are left in, or they're left in for future use because Mr. Ellsburn needs those entries, and the rest were not needed anymore because the meetings already took place. So, I'll represent to you on behalf of the office and Mr. Ellsburn. There's no other calendar beyond what we gave him. If he wants to request it for other days, we can give him what we have there. And just sort of as a practical matter, this kind of relates back to Anonymous. Anonymous has a series of kind of serial requests for Mr. Ellsburn's calendar. So effectively, we're retaining the calendar because we have all these sort of open requests that we would, of course, never dispose of documents that are subject to an open request.
Let me ask you, it repeats in many times MLB scheduling. Is that Major League Baseball?
No, it's Maryland and Breed.
Okay. Okay.
So I think
I want to make sure because,
I think it's just, frankly, frustrated and annoying knowing that someone in that position apparently doesn't need a calendar. I think that's at the heart of it, and it just is a frustrating feeling. I get it. But unless someone deposed him and asked, how do you keep track of your time, and you get some real answers there, maybe he's just trained himself to not need the calendar for purposes like this. I don't know.
Yeah, sorry.
I'm just, it's just pure speculation.
Let me just ask something very specific. On page 1248, it's an entry for July 12th, 2019. At 12:30, it's been redacted. Do you have can you explain why the redaction there?
I believe that's a personal entry. I'd have to confirm, but I believe that's a personal entry, like he's meeting with his kids for lunch or something like that.
Okay, and then let's go to 2 pages down, 1250 at, looks like, I don't know, it ends at 3 o'clock there. It seems a little, I don't know what's going on there. But it seems like something, it looks like something was added in there. I don't know what's going on there.
Bottom of page 1250.
Yeah. You have a little redaction, and then it looks like something was added, even at the top of page. I don't know.
I think that's just the copying. I think the Darius Anderson entry above that and the full board vote entry at the top, or I think they were just entries, but it might be a product of the copying, that it looks faint or something.
Okay. I mean, then you look on the next page, page 1251. Well, that's a pretty full day there.
Right.
So,
right, because this was, and the entries from there to the end, except for the weekends, are more detailed for that reason, because they're, those were current. Those were within sort of the general kind of retention period that Chief Ellsburn uses.
Was he on vacation for those other periods of time?
Which periods?
Like June.
No. Sorry.
Like what was happening with all the previous dates going back to April?
There were entries. There may have been entries for those days that were those. They're not retained, so they were removed from the calendar. That's what I was. That's sort of the factual underpinning of this. Is that?
Wait a minute. So
it's not. Sorry. Go ahead.
Wait a minute. Go on. Finish with your point.
The reason there aren't entries, there probably were entries. I'm pretty sure there may have been entries.
Yeah.
Likely on those other days, and as I said, the retention practice in our office and for Mr. Ellsburn is he keeps his calendar for about 2 weeks, or he did at this time, and so those predate the time that Mr. Petrellis made his request. So those entries were removed, and the reason that there's still some entries is because those are kind of ongoing meetings, so they still have future use, so they weren't disposed of. Yeah.
And they began at a certain past period of time. I get that point.
Right.
Okay, so, So that's the equivalent as if I threw out the 2019 calendar into the garbage.
Right.
Okay.
And this is pretty much the facts of the Steve Cava matter. That went to the Ethics Commission.
Yeah, I know, but ethics can make their own decisions of how they make it. We don't necessarily have to follow it, because that's also an administrative review.
That's true.
So it's not law, and it doesn't have that weight unless they can find a violation and they can impose enforcement. And if they find a violation and don't do any enforcement, it's more or less the same thing that we come up with. It's just that they have a lot more staff than we do and can do deeper investigations than we can. And we do our investigations in public, they do it in private.
Yeah, and I think they have their own kinds of enforcement powers too.
Yeah, but sans the enforcement part, the point is how they come to their decisions doesn't weigh that we have to agree with them.
No, you don't have to.
They're not necessarily superior to us. So
no, I'm just citing it as instructive authority.
Yeah, no, it's a point. I get it. Okay, are we done with this part? Oh, Vice Chair Wolf, do you have anything you wanted to add? You had your hand up.
It was a long time ago when it was no
Okay, Member Yankee, do you have something else? Anybody else? Okay, shall we move to rebuttals? Okay, go for it, Mr. Heckel, you first.
Oh, I'm first. Okay, I think yep.
Go ahead.
So I think we covered a lot of the ground. I think we really dug into a lot of the factual and issues in terms of the requirements here that are operative. So again, this sort of comes down to the basic dispute is sort of two areas of law, two areas of requirements. There's Sunshine Ordinance, which requires you to produce documents when they're requested. Certainly, if Mr. Ellsburn's calendar existed in a different form at the time Mr. Petralis made his request, we would have provided those records. We provided the records as they existed at the time. And then separate and apart from that, there's record retention laws, which is set forth, and there's a section in the Gov Code. It's cited in one of the letters from the city attorney to the Ethics Commission. And also local admin code 8.1 to 8.3, which is not part of the Sunshine Ordinance. And basically those requirements set out that departments should set out record retention policies that reflect specific categories of documents that have retention. There's some documents have very specific retention from other areas of law, like health records or personnel records, things like that. And so the document retention policy kind of reflects that, and then sets forth other types of documents that might exist which are subject to retention because they have ongoing significance, or as we've classified these types of sort of day-to-day things that are used for reference, calendars, day-to-day notes, even day-to-day emails, are not subject to retention. And because they're not subject to retention, we submit that there was nothing was done improperly here. They just exist as they existed at the time of Mr. Petralis's request, and we gave him what we had, and we're not withholding anything. So that's basically our position. I'll close.
Okay, thank you, Mr. Petralis. You have 3 minutes.
I don't know how you guys are going to vote. And I think the questioning and the answering from the mayor's office have been educational and enlightening. And to go back to what I said during public comment, if this meeting were airing on SFGov TV, it would be so much easier to say to the 11 supervisors and all of their staffs, you need to address this issue of the mayor's office and the chief of staff is not retaining a detailed calendar. We can go back to what happened with Steve Cowa and show that it's an ongoing problem. And if we want accountability and transparency at and from the mayor's office, we need to have the chief of staff retaining a very detailed daily calendar for at least 2 years and providing it to the public upon request. It is really a blot of shame upon San Francisco that we have this task force that is devoted to Sunshine, and yet Sunshine ends because it's not on TV. It's really unfair to the public. That said, I'm not sure where I would go after you have made your decision. If you vote in favor of the mayor, well, regardless of how you vote, I want to pursue this further with the supervisors. Something must be done to change the law and maybe create a moral imperative that requires London Breed, a well-known foe of Sunshine, requires her staff, everyone at the staff, especially the chief of staff, to maintain this calendar. And finally, I just want to end with what I saw tweeted several times today from Speaker Pelosi regarding the quote-unquote impeachment trial. What are they hiding? What are they hiding on Sean Ellsburn calendar? That's the question I have tonight. Thank you.
Okay, members.
I mean, I'm having a tough time simply because of the ethics decision and him not being a department head, and it's tough because it's unsettling. But I don't, I think that they produced what there is, and there just isn't a lot of it, and it's annoying. So.
I mean, when we dealt with this same issue with the previous chief of staff, the real issue that I got caught up in is the fact that we have a situation where the records that do exist are consciously being deleted, and whether or not like there is any city retention policy, because these are public records. Like everyone acknowledges that the calendar is a public record. In most cases, public records are protected by some sort of retention policy. But what we dealt with in this previous case and this one now is that these are public records being destroyed in light of a lack of retention policy. I do want to go back to this document, however, in that there's a couple different ways that we can parse out letter B, the second sentence. One way to read this is that the last sentence, that they have been retained for periods prescribed for records for substantially similar records. And I would argue that a Prop G calendar and a non-Prop G calendar maintained by the chief of office are substantially similar records. So where I'm coming from is in reading the actual retention policy provided to us tonight, it appears that a calendar is a substantially similar record to a calendar, and that seems to refute this B section, but that's really the only thing I have going for a violation at this point, and it's not a violation of the Sunshine Ordinance. It's a violation of this 6-year-old policy that hasn't been signed by the current administration for some reason.
I'm kind of in the same place as Member Martin. I think, actually, to Mr. Petrellis' point, to me, it seems to be a bit odd for sunshine purposes why you would actively go back and delete. I mean, I have an Outlook calendar at work. I'm sure a lot of us do. I can't ever remember going back and deleting things. I don't have time to go and do that. It's like I wake up every day and be like, oh gosh, first thing at work, let me go delete my prior entries. That just is a waste of time. I could find what I did 5 years ago on my Outlook calendar. It's still there. I don't see the purpose of that. That being said, I'm not sure I see an actual violation. I see kind of a flimsy, ambiguous records retention policy, and I think that absolutely needs to be tightened up, to your point. But I'm not sure I have a really good, violation that I can see. Maybe this isn't the best, like you said, maybe this is something that needs to be added, or a tweak that needs to be made to the ordinance or something, or maybe we just need to make a better, the mayor's office could make a better records retention policy that would direct staff to keep calendars and emails and such. But I'm not sure poor practice necessarily means a violation. That's kind of where I'm at.
Well, and Chair, can't we write a letter to the Board of Supervisors bringing up the issue or something like that?
Or perhaps include in the annual report that.
Yeah.
Well, but for the purposes of the case in front of us, is there a motion? I mean, that, we could always do that.
Right.
But let's try to close the case out. Is there a motion?
I don't see a violation, but I don't feel comfortable making a motion for no violation when it does seem to go against this one potential read of this retention policy.
This was always, I know we had addressed this before, but if we make the motion finding no violation versus the motion for a violation then it failing.
So if you make a motion, if you, generally the complaint is forward, so you assume, if you assume that there's a violation, you generally put that forward. If the motion fails, then obviously nobody agrees that there's a violation. If you specifically state that there's no violation, it can be said that you're making a statement about that particular function. So the question then is, if you make it too general, then it can apply across the board. Okay, you're basically taking a position on a you're taking a position on of a specific factor. Okay, if you're not specific enough about it, that can be interpreted as applying everywhere. If you just put it on the floor that there's a that's why I always like to say there's always a violation, and then everybody there's always an assumption that there's a violation, and then when we vote, it determines whether the violation, everybody believes that the violation is real or not. That way the violation stays with the subject matter of the case itself, and we're not creating a new animal.
Can we do a motion to table it that isn't a motion to find no violation, or does that not work either?
Table it?
Yeah.
Well, if you table it and we end the meeting, then the motion, it disappears.
Exactly. That's intentional. I don't see a way to make a motion for a violation that feels solid. I refuse to make a motion that there's no violation because I see it interfering with this mayor's office's own internal document. So
Well,
all I can come up with is a motion to
You don't
close
have
the
to-
case.
You can make a motion. I don't think it's a requirement that you can, vote. You have to vote in support of your motion. The question before us is there a violation or is there not a violation?
All right, I
But
make a motion for no violation then.
On this case.
On this case.
Okay, so moved by Vice Chair Wolf.
I'll second.
A second by Member Martin. Okay? All right. Any public comment? Any further?
Yes.
Yes, Anonymous, go ahead.
So I understand we all want to get out of here, but there is a violation. It's just Mr. Petrellis hasn't cited it, and it is on page 1,270 of the record, which is page 60 of your PDF. And in this case, maybe Mr. Petrellis hasn't realized it, but they gave you 3 different types of redactions: personal information, official information privilege, and personnel hiring information. And the law requires under 6726 that, remember Mr. Heckel couldn't tell you which redaction reason was the one you asked him about? That's because they're violating 6726, which requires that each redaction be keyed by footnote or other clear reference to a redaction reason. Now, maybe Mr. Petrellis doesn't care about it, but that violation is there. And I wanted to finish with Mr. Heckel raised me and my request in this complaint. And that is true. Every 7 days, I request the next 10 days and the previous 10 days of the 3 top officials and the mayor. And I do this because it forces them to retain everything. And, this is obviously not advice in any way, including legal advice to Mr. Petrellis. It's only direct at the task force. I'm actually negotiating with them to say, okay, I won't do this every week if you retain it for 37 days. And there are ways to get what you want, even if they've found some loophole in the Sunshine Ordinance. Thank you.
Thank you. Is there any other public information, any other public comment? Okay, members? Are you ready for a vote?
Is it closed or?
It's closed, yeah.
I just don't understand what the motion's for.
The motion is for no violation.
Okay.
Best one you could hope for. Any other questions?
Too many questions now.
You're just not used to that here.
Should we take the vote?
Yeah.
Yeah, call the roll.
Vice Chair Wolf?
No.
Member Martin?
What am I?
Wait, what? Find no violation. What was
Yes,
your
I voted
motion?
no. As Chair Wolf pointed out, I don't have to vote for my own motion. I'm trying to move this thing along.
You voting no, Member Martin?
Yeah, no.
Member Yankee?
No.
Member Yankee, no. Member Tesfaye, absent. Member LaHood?
No.
Member LaHood, no. Member Hinsey, absent. Member Highland?
Nope.
Member Highland, no. Chair Wolf?
No.
Someone want to make a new motion?
So I move to find in violation of 6726. Information that exempt from disclosure shall be masked, deleted, or otherwise segregated in order that the non-exempt portion of a requested record may be released and keyed by footnote or other clear reference to the appropriate justification for withholding required by section 6727 of this article.
I'll second that.
And in addition, this work shall be done personally by the attorney or other staff member conducting the exemption review.
Okay, so the first motion was made by Vice Chair Wolf, second by Martin, for no violation.
And it failed.
And it failed, exactly.
So now we're back to
Square one.
0, yeah. So now I'm making a motion.
Making a motion to find a violation of 6726.
Correct.
And I seconded
And you
that.
seconded. So we do a vote now?
And now we go back to public comment.
Yes.
Anonymous, go ahead.
Obviously, obviously, this is exactly right. They have to tell you which redaction is which justification. That is all. Thank you.
Is there any other public comment? Seeing none, are we ready for a vote?
May I comment on this, or it's closed out?
No.
This was never raised once in the file. I didn't even get an opportunity to be heard on this issue, so I'll just, you can note it or not.
Well, I brought up 6726, I think, a couple of times. Well,
Floor's closed.
We should probably ask him we should consider asking him a question so that there is that opportunity that the issue that hasn't been brought forward is discussed.
do you want, are you asking that
Sure.
through the chair? Okay.
Mr. Hinkle, what is your perspective on the proposed motion?
So the first I've heard of this was public comment from a non-party. I wasn't aware procedurally that a non-party can raise a new basis for a complaint in a file, which we have never been given the opportunity to address in any of the filings or in the argument. I understand he's referring to page 1270 and saying the redactions weren't identified. There are redactions for personal information, such as cell phone numbers. I think that's clear from the context what those are. Call-in information, that should be clear from the context what those are. And the personnel sort of hiring processes, issues, redactions to protect the identity of those people. So I think that's clear from the context if you look at the redactions, what they're for. But I mean, I haven't really thought about it in depth because it wasn't raised till now. And if this is just what I heard was this was just a formality to allow me to speak so that you could say that I was allowed to address it. And I also heard that violations of the ordinance are presumed against city officials and city staff when they come in. So guilt is presumed in this chamber is what I've heard. I'm not sure what city staff are supposed to think when they come in and they're assumed to be a violation. But if that's where we are, that's fine. I'm happy to engage more on this issue. I just wasn't aware of it until Anonymous brought it up.
Well, let me make a correction on that. It's presumed that all documents are public documents until it is respondent cites that it is not, or that it can be withheld. So if it's the presumption is that if somebody's withholding a document, if they don't provide a reason why it's withheld, then it's presumed that there's a violation.
Okay, if that's what was being represented, that's fine. I didn't understand. I thought it was sort of a blanket
But it's
statement.
implied. It's just implied. Okay, and that way it allows for the motion that is being made to stay with the specifics of the case itself, and it allows the task force to then either vote it up or vote it down, because it's a complaint that's coming to us first. So we're assuming, okay, there's a violation unless somebody says, oh, no, it's not a violation because of the law states this or the law states that, okay? But if we then have to word a motion that it's no violation, then we have to be very specific on how we're stating that. If we just say, is there a violation of what's before us on the floor, and we vote it up and down, then it stays encapsulated in that case for that case. And then somebody can't then imply that it applies for all kinds of other things. It only applies to the merits of the particular case itself. That's the danger of us doing, finding, in finding a no violation. In stating it, just stating no violation, because then somebody can misconstrue it.
Why not just state that there's no violation based on the complaint as the complaint was filed and argued, and the violations were identified by the complainer? Because
in the past, people have interpreted that as meaning that it applies everywhere, and not just to that particular, the merits of that particular case. If we assume that if there's an assumption that there's a violation and it's put before the body, then, because the complaint is coming in with a complaint, I believe that there's a violation. If there's an assumption that's put before us that that violation is there, and we say, no, we don't agree with you on the complaint, then it's on the merits of the complaint that we're finding that we don't agree.
So you're saying the violation's assumed once you make it past the complaints committee? Is that what you're saying?
Well, it's just kind of, it's like I'm saying, it's somewhat assumed that it's there until the respondent says, no, this is exempt from so on and so forth. It's just, we've had just so many problems back and forth in trying to figure out which way is the right way. And it's never been clear, but we've had some problems in the past with just finding no violation, or just versus closing, do we just close the file? Like, no, some people would say, okay, no violation, then they won't even make a motion, okay? And then what happens? We're sitting here waiting for the end of and we don't necessarily have a policy with regards to that. Sometimes people feel that maybe there really still is a violation, they just can't think of one, versus absolutely no violation. So it's a little bit of a procedural conundrum for us. Go ahead.
I understand.
I just want to clarify that our process didn't allow for you to speak during the normal process, so the formality of asking you a question was the only way to allow you to actually engage at this point. So I was a little frustrated to hear that it was a formality of letting you speak so much as trying to figure out a way to work within the rules to allow you to have a comment after a motion had been made.
Yeah, I appreciate that. I would just submit it's procedurally improper for a non-party to raise a violation that was never discussed during the course of the hearing.
We give public comment, and that's exactly the point of the public comment. It adds to our deliberation. We have many times changed our deliberations. We've added violations, different code things. If you go read our records, which are on audio right now, you'll see examples of that. So we're trying to get to the best decision for the people.
Yeah, I mean, it's your prerogative. I just think it puts the respondent at a disadvantage.
So, thank you. Just debating this particular motion, I would just say, with regards to that, what's been said is I'm wondering if information that is exempt from disclosure includes what is in the retention policy as far as B is concerned. Is that a reach? Records and other documents or periods that are expressly addressed, okay? information that is exempt from disclosure. That's basically kind of what it's saying in a way. I don't know, is it a reach, not a reach? I just want to kind of put that out there as food for thought. I think the question of that, we get responses from members of the public and from petitioners all the time that with regards to subjects that are applicable. I think this somewhat speaks to the actual complaint because of the so many days that seem like things were deleted, okay? And that's part of the ordinance. The ordinance says exempt from disclosure shall be masked, deleted, or otherwise segregated. So, I don't know. I'll put that out there. That's it. It's somewhat of an afterthought now. All right. Well, was there a second to my motion? You seconded it, right?
seconded it.
Okay. All right. So we've had public comment. We've had some additional. Let's vote. Okay. Please call. Sure. Thanks. Please call roll.
Chair Wolf? Who made the motion?
Pass.
Vice Chair Wolf?
Aye.
Member Yankee?
No.
Member Martin?
No.
Member Tesfaye absent. Member LaHood?
No.
Member Hinsey absent. Member Highland?
Aye.
Highland, aye.
You have to call me again.
Chair Wolf?
No. The motion fails anyway. Okay. So I think with that, we'll, it's assumed that there's no violation. We'll close the file, and we'll take it from there. Okay? All right. Thank you, everybody. I appreciate it. It was interesting deliberation, for sure. Okay, let's call next item and see if we can wrap this up quick.
Item number 11, file number 19091, complaint filed by Anonymous against Mayor London Breed, the Office of the Mayor, Hank Heckel, Sean Ellsburn, Andres Power, Andrea Bruss, Marjan Vilhauer, Jeff Creighton, Sophia Kittler for allegedly violating Administrative Code sections 6721, 2627, 6729-7 by failing to respond to a request.
No, we're going to lose it.
Because he's going to leave too.
I have to make a phone call at 9:40.
What?
Request for public records in a timely and/or
I have to
complete
leave in 10
manner.
minutes anyway.
Okay, so we have a bit of a procedural issue here because folks have to leave and have other responsibilities. So we're gonna lose a member in 15 minutes, and we have somebody who needs to
I need to leave in 10, but
needs to leave in 10.
I can message them and say that I can, if we can dispatch this in 15 minutes, I can message them and say that the
Well, we
call's
can
5
try.
minutes late.
Huh?
Really? Have we ever discussed anything in 15 minutes?
No.
I think it'd be better just to start fresh.
Do you want to continue? We can do that.
Has already gone out, so.
It's up to you folks.
Yeah, I'll make a motion to continue.
Great.
Second.
So moved by member Yankee, second by member Martin. Apologies to parties, but I think in due time, plus it's 9:30 and the building usually likes us out by now. Okay, any public comment on the motion to continue? Seeing none, please call roll.
Member Yankee?
Aye.
Member Yankee, excuse me, Member Yankee, aye. Member Martin?
Aye.
Member Martin, aye. Member Wolf?
Aye.
Member Wolf, aye. Member Tesfaye, absent. Member LaHood?
Aye.
Member LaHood, aye. Member Hinsey, absent. Member Highland?
Aye.
Member Highland, aye. Chair Wolf?
Aye.
Wolf, aye. The motion continue passes.
And again, apologies for that. Okay, just okay, so can you call item 12?
Item 12, reports from Sunshine Task Force committees.
Are there anything highlighting out of committees? No, okay. Any public comment on this item? Okay, let's move to the next item.
Item number 13, Sunshine Ordinance Task Force Chair's Report.
Okay, so I have a couple of items. One is the referral from Hartz versus the president of the Board of Supervisors. That came back. It was happened on Friday. I watched it. Not very happy the way it went. It happened, but it did not go in Mr. Hartz's favor as he expected. I have engaged the investigative department at the Ethics Commission to ask them about the level of discovery they did, and I didn't see any of our documents, our order of determination or what have you, included in the record that they presented to the commissioners. So I was a little concerned about that. But one thing I wanted to notate is that before. So I was on the task force pre-2012, and we had been working with the Ethics Commission to create new rules on sunshine complaints that came to them directly and sunshine referrals for enforcement that came from us. And it wasn't in there in the probably 4 to 6 months that I was working on it, but somehow after, it wasn't approved by the time that I left the task force at the time, but it does say now that the Ethics Commission may defer to the Sunshine Task Force order determination based upon the referral or de novo, meaning like new. And that's what they did. So basically, the commissioners did not consider, as far as I can see, and from the testimony and the discussion, they didn't consider any of the work that we did for all those years, going back over a decade, including a official position and memo from this task force in 2012 to the entire city family regarding that particular issue, which is the adding of 120-word written public comment in line in the minutes to be placed somewhere prior to the last item on the agenda for adjournment and the signature from the clerk of the board. So meanwhile, every other city commission and board does it the way that we have put out. So I'm a little dismayed by that. It calls for, if you feel strongly about it, it calls for, supporting an amendment to try to correct that. One thing I did do, though, and because I've been involved in parliamentary procedure for so long, I've consulted with some of the discussion boards that I'm in touch with other parliamentarians, and without citing the case, without citing what city I'm from, or the Sunshine Ordinance, just asking them based on Robert's rules, where there is no specifics anywhere in law, what's the default? And the default is that any submission for items of public comment that are pertaining to items on that agenda should be placed verbatim in the minutes. So it supports what we've been, our position for all these years. So That's a starting point for the discussion. That's not, I wouldn't say it's necessarily definitive, but in the case for the Board of Supervisors, where there is no rule that they've created, it defaults to Robert's rules. So that's kind of the starting point for discussion there. Second is, this is, I believe, the end of a 2-year budget cycle. So one thing that we don't do and start early enough is to get our asks in, our requests in. So because, and that leads to the other point, is that our terms are up for, our terms end April 27th of this year, except for Member Hinsey, according to the schedule. If we wanted to submit something for the budget, now is the time to do it, because once April comes around, everybody's submissions and requests will probably already be in. So, if we're looking for stuff around the database stuff, if we want, something around, staffing or, something like that, that's, now's the time to think about it. I'll say, let's, our next meeting is February 5th. So you got a couple of weeks, 3 weeks, think about it. If there's anything burning. And this could include, like, you want brochures to be made up so the public, can be informed about what, that there is a Sunshine Task Force, or what Sunshine Law is, or something like. We've done those things in the past too.
I think we had a short list at the retreat.
We had, but it wasn't, I have those items, but there wasn't that many. I think they think you need to think about it a little bit deeper. There's that. Go ahead.
And we did talk about that at the meeting previously. And it does seem like some sort of paid role that is the ambassador of Sunshine to the departments, because all of the EOTC work ends up being like, we should do this, but then there's no paid staff, so the people that are spending their time at the meeting are then creating work. And so it does seem to me that if we're going to put a request for budget staffing, that staffing should be an intermediary between both the community and the city workers, with an advocacy role as opposed to a clerk type role, which is what our existing staff is.
Even an intern, maybe.
Well, interns come and go. We're talking about something ongoing. I mean, I get called to make presentations to lots of boards and commissions in the city. So that's my own, I'm doing that on my own personal time, my own dime on transportation. I'm not getting reimbursed for any of this. It's, my love of the work, but when other people are asking me to take time out of my day, during the day, I have to take a day off to do it, that's not quite fair either. And I don't like to put it upon the administrator, because they're really busy, they're juggling 3 or 4 things at a time to make sure this thing runs smoothly. But I actually would like to flush out more staff. I think it's needed. It's nothing against the quality of the work of our current staff, past or present. I just think that there's a lot of work that can be done, and it could ease the workload and ease the stress on people.
Well, and outreach and education is way beyond what the administrator's job description is, so.
Right, so like I said, think about it. If you can come up with something cogent, we can discuss it in the February meeting. We can get some input from Cheryl, what she thinks about that, and we'll move it from there. Make it as inclusive a process as possible. Okay, next item.
Item number 14, staff report, complaints, and communications.
Just real quick on that item, Cheryl, a couple of date checks for you. Yeah, on item 1, tentative hearing schedule. You've got February 17th and 25th, which are Mondays. Did you mean Tuesdays there, 18th and 26th?
Yeah, I did mean.
Especially because the 17th is a holiday.
Did mean the 18th, you're right, that's correct.
Okay. And probably the 26th for the next one?
Yeah, probably.
Okay, great. I just wanted to bring that.
I'll send out a notice to everyone.
Sure.
Do you have anything you want to report, Cheryl?
Well, between, Anonymous has filed many complaints. I know that between November 13th and December 30th, he filed 20 separate complaints. So that's taken up a big bulk of the number of complaints that have been in. There haven't been a whole lot of independent complaints from various members of the public. Pending complaints before the task force, the statistics are there. The file numbers for Javad Mercedes, David Steinberg has informed me that he will let me know when he's come to the conclusion of turning over all records. He's found more than expected, and he is working on providing them for Mr. Mercedes, but he's not prepared to give a report on that to the task force probably until April or May.
Okay.
Mary Miles, tentatively scheduled for February 5th. The notice for the February 5th hearing has gone out, and Ms. Miles will be present. I've given her copies of her records. She's been in the office.
Okay, good.
We had 3 separate communications from Anonymous, December 11, November 15, and January 14. And requests from community persons from November 16 until January 4. All of those emails are reflected in the memo.
What is 17-110? It's under pending issues. Data SF report on implementation of Sunshine Request Management. Oh, that's our outstanding one.
Yeah.
Okay. Right, okay.
Any other questions?
Yeah, well, we just can't. We can't vote. Right. Okay, so one thing I will note that there won't be an administrator's report on the February 5th. This will take place of that. If there's anything specific that you want from the administrator to report on, please email Cheryl directly, and she'll CC me on any response with regards to that. Is that it? Okay, is there any public comment? And I didn't ask for public comment on the chair's report. Is there any public comment? Nope. Okay, seeing none, please call last item.
Item number 15, announcements, comments, questions, and future agenda items by member of the Sunshine Ordinance Task Force.
Members, are there any? Hearing none, please call the next item.
Item number 16, adjournment.
A motion to adjourn. Oh, we are
So adjourned.
by a standing vote. Thank you, Mr. Heckel. Have a good night.
Thank you.
Thank you.
That's the longest she stayed ever. That's pretty good.
Yeah, no kidding.
Yeah.
Well, she's growing up.
Her endurance.
We used to take midnight breaks, remember?
Yeah, we used to, I know. It's a good exercise. I've been trying to exercise her a little bit because I'm trying to